Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through the next 3 hours of Courtlandia today. We'll start in Allegan County, Michigan. This is Judge Skocelas.
In charge of domestic violence. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Herring for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pre-trial and a jury trial, Your Honor. Thank you.
On a not guilty plea, set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you were released from the Allegan County Jail on a $500 personal recognizance bond. This is also a protective bond. We'll continue bail in that amount with those same conditions until further order of the court. Your case to be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. The public defender's office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your pretrial conference. The date and time of your pretrial conference will be sent to you by the clerk's office in the mail. So you are free to hang up the court proceeding this morning. Be looking for that in the mail, okay?
All righty, thank you.
Okay. Have two files on Angel Denise Hayes, 260956SM and X464730B. ST. Both of these are based on the same citation issued by the Michigan State Police on a charge of driving without having a driver's license and operating an uninsured motor vehicle. The insurance charge requires fingerprints, and we do not have any fingerprints on file at this time, so I'm unable to proceed to an arraignment. Ms. Hayes, you need to get fingerprinted on this case before I can start the court process. We had an order for fingerprints that went out on March 30th. Today's April 22nd. We still don't have any prints on file for you. How long do you need to get fingerprinted?
I never heard, they never told me that I had to get fingerprints. Nobody got in contact with me and told me I needed to get fingerprints. I got no paperwork on any of that.
You need to get fingerprinted. How long do you need to get fingerprinted? You'll have to come to the Allegan County Jail to get that done.
Well, I don't have no transportation right now. Probably, can I do it this Friday?
Oh, sure, not a problem. I'm going to instruct the clerk's office to reset this for arraignment. Between now and then, get those fingerprints done, and your adjourned date, we'll do it just like this over the video. So you are free to hang out for the court proceeding. Be sure to get those fingerprints done. Be looking in the mail for the date and time of your new arraignment. Okay?
Okay, thank you, sir.
Thank you. The next one, Johnson. Next file is file 260986SM, People versus Matthew Chandler Johnson. Here today for arraignment on multiple files based on the same citation issued by the Allegan County Sheriff's Department, one for operating an uninsured motor vehicle, also a civil infraction for holding an electronic device while driving. On the insurance violation, fingerprints are required. We don't have any fingerprints for you on file, Mr. Johnson. An order for fingerprints was sent out on April 2nd, and as of today, we don't have prints for you, so I'm unable to proceed to arraignment. You will have to go to the Allegan County Jail to get those prints done. How long do you think you need to get that accomplished?
Why am I having to get prints done?
Under Michigan law, on a charge of operating an uninsured motor vehicle, you can receive up to a year in the county jail. That charge requires fingerprints.
Okay, just any day really I can do. Just
Okay.
it has to be It has to be before like at 12 o'clock. After 12, I meant.
Well, you need to get to the jail while they are open. Check what hours they're available for fingerprints. I'll instruct the clerk's office. You're going to get that done. They will give you a new date and time for an arraignment just like this, and it'll be sent to you in the mail. So you're free to hang out from the court proceeding. Check with the jail on their hours for fingerprints. Get those done, and you'll get in the mail the next date and time for arraignment. Okay?
All right, thank you.
Thank you.
Have a good day.
You too. Case is file 260985 OD. This is the case of People versus Stephen Michael Mills. Here this morning for arraignment charged through a citation issued by the Allegan City Police Department on a charge of operating a motor vehicle as a minor with a blood alcohol content. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Mills for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He's entering a plea of not guilty and does qualify for a court-appointed attorney. We request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Okay, just to confirm, this is a no jail offense, but you're appointing counsel?
Yes, Your Honor. He had a previous case with a court-appointed attorney, and this is part of an offer that was in that case.
Or not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail in this case at $500 personal recognizance. Condition of bail is you not possess or consume any alcohol, marijuana, or illegal controlled substances while your case is pending. Your case will be set first for a pretrial conference with the Allegan City Attorney. If not resolved, it'll be set for a jury trial in this courtroom, District Courtroom A. The Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at your pretrial conference. Date and time of that will be sent to you by the clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting that in the mail. Okay?
Okay, thank you.
260707 SM, People versus Joshua Aaron Morris. This morning for arraignment, charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office on a charge of malicious use of a telecommunications service in a domestic relationship. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Morris for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is pleading not guilty and does qualify for a court-appointed attorney, and we request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
Or not guilty, please set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount at this time. Your case will be set first for a pretrial conference with the prosecutor's office, and then for a jury trial in this courtroom, District Courtroom A. The public defender has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at the date and time of your pretrial conference. The actual date and time will be sent to you by the clerk's office in the mail. So you are free to hang up the court proceeding this morning. Be expecting that in the mail. Okay?
Okay, thank you.
About 260856 SM, People versus Dorothy Jane Pitts. Here this morning for arraignment, charged through a misdemeanor complaint issued by the Allegan County Prosecutor's Office on a charge of assault and battery. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Ms. Pitts for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading, and Ms. Pitts will be pleading guilty today, Your Honor. Thank you.
Ms. Pitts, is that what you've agreed to do?
Yes, I did slap her.
Okay,
I
but
do.
do you wish to plead guilty to the charge of assault and battery?
No, I do not.
No, you do not. Okay, we're gonna have you, well, at this point then, I'm gonna enter a not guilty plea. Or did you talk to her about counsel, Mr. Badger? or
I
not?
did, Your Honor. She does qualify.
All right, then we'll be real quick here. Will a not guilty plea set this for a jury trial? Indicate you're requesting an attorney at public expense. Court file shows you released on a $300 personal recognizance bond. Bail will be continued in that amount at this time. Condition of bail is you have no contact with a Naomi Saints while the case is pending. Your case to be set first for a pretrial conference with the prosecutor's office, and then for a jury trial.
He cut the feed, but that's okay. So I don't know if you saw me on camera, but I was laughing my rear end off right there. I have some familiarity with Allegan County, and that sort of thing right there is just pure Allegan. Yeah, I slapped her. Are you guilty? Hell no. I love it. Good morning once again, everybody. TCF Live on a Wednesday. It's so great to have you all with me. Let's do this. Let's go to Lake County, Ohio. Say good morning to Judge O'Donnell.
Yes, sir. Prior to coming to court today, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
Prescription medication, yes, sir.
What have you taken?
Depakote and Cogentin for my bipolar schizophrenia.
When did you take it last?
Approximately 3 hours ago.
Does it affect your ability to understand what's going on here?
No, sir.
Did you get a copy of this indictment?
Yes, sir.
You're going to plead guilty to count 1 assault, and then count 2 would be dismissed at sentencing. Is that your understanding?
Yes, Your Honor.
Okay, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, then stop me. If you want to talk to Ms. Tomasic some more, let me know, and I'll give you more time. You understand that?
Mm-hmm.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
No, sir. Well, yes, sir.
Okay. If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Understood, Your Honor.
After the witnesses are done testifying for the prosecutor, you would have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
No, sir. Yes, sir.
All right. If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, agreed.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Agreed.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Agreed, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to count one?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Agreed.
Assault is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
Cuyahoga, I had 158 days left, and I completed a halfway center as I'm trying to go to now, but it was called Oriental House. I'm not sure if you're familiar with that.
I am, but were you in prison and then you went there?
No, I had almost completed.
Or were you on probation in Cuyahoga?
Yes, I almost completed probation.
All right.
And me and my probation officer, Bill Caboris, were adequately talking on and off when I was at CBCF, and I was struggling with use, and then I had completed the program successfully because I had stopped being around peer correspondents who were using, and this rehab, they allow you to smoke nicotine, and all I want to do is just, reintegrate into my community and stay sober, so I don't plan to go here and mess up or F up.
All right. Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand if a prison sentence is imposed in this case, that you might have to serve a period of post-release control as part of the sentence for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and you violate any conditions, the parole authority could send you back to prison for a maximum of 9 months as part of this sentence. Do you understand that?
Understood, Your Honor.
If the violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Understood, Your Honor.
And if that were to occur, the maximum prison sentence for the violation of that sort would be the greater of 12 months or the time you have left under the post-release control. Do you understand that?
Yes, Your Honor.
Do you understand if a prison sentence is imposed, you are eligible for judicial release?
Understood, Your Honor.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Understood, Your Honor.
Have you had enough time to talk to Ms. Tomazik before pleading guilty today?
Yes, Your Honor.
Has she discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice she has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
All right, Mr. DePiero, if this case went to trial, what would the evidence show?
Your Honor, the evidence would show February 21st, 2026 in Lake County, Ohio. The defendant, Sam Tez Tucker, had contact with Painesville police officers. Painesville police were talking to the defendant as they were investigating an unauthorized use of motor vehicle case. The officers were going to detain Mr. Tucker at such time as Mr. Tucker physically got into an altercation with the police officers. Through the course of the officers trying to detain the defendant then threw an elbow back towards the jaw of Officer Mario Mazza, who's a certified peace officer who was on duty, wearing a uniform, driving a cruiser, in the line of duty at that time. The defendant did have contact with Officer Mazza's jaw. Through the course of the defendant fighting with the officers, Officer Mazza sustained cuts on his hands and a scrape on his elbow, and he had soreness to the jaw.
Ms. Tomazik, anything to add to those facts?
Nothing on the facts, Your Honor.
All right. Mr. Tucker, did you hear what Mr. DePiero said that the facts would show if the case went to a trial?
Yes, I clearly understood that, and I was saying 2 punches to the back at that time, and they slammed my head to the ground. But
Okay.
it's agreed. I hear what counsel said.
And did that occur?
Yes,
All right, then what is your plea to count 1, assault, a felony of the 4th degree?
guilty.
Ms. Tomaszek?
Your Honor, I reviewed the written plea of guilty with Mr. Tucker before coming into court, and he's prepared to sign. So date here and sign here. Today's April 22nd. Your Honor, for the record, myself and Mr. Tucker have signed the written plea of guilty.
Your Honor, I witnessed those signatures. I signed this form myself. Having the court's permission, I'm approaching and presenting them to Your Honor.
Thank you. All right, Mr. Tucker, is this your signature on the written plea of guilty?
Yes,
Did you sign it voluntarily?
yes, sir.
Do you want me to accept that written plea of guilty?
Yes, Your Honor.
Accept the written plea of guilty. Defendant was present. Witness Tomaszek advised of all of his rights, been a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. Will accept his plea of guilty. Find him guilty. Count 1, assault, a felony 4. I'm going to refer this for a pre-sentence report, a psychological evaluation, victim impact statement. Sentencing will be May 26, 11 a.m., and the bond is revoked. Anything else, Mr. DePiro?
No, Your Honor, thank you.
Ms. Tomaszek?
Nothing further, Your Honor. Thank you.
All right, we're adjourned.
All right, Sam.
Once again, everybody, good morning. It's TCF Live on a Wednesday. Programming note, we're doing 3 hours today, not 4, just so you're all aware. Let's go to Michigan. Judge McNally.
Monthly or more on demand of probation. So if you're clean on all your tests in the beginning, I'm going to revert it to monthly testing after 3 months, or probation can still demand that you submit to testing. I want you going to AA, NA at least 3 times a week now until you're in outpatient treatment. I'm ordering outpatient treatment. Once you get in outpatient treatment, you no longer have to attend AA or NA. So outpatient treatment, AA 3 times a week, or NA until you're in treatment program, attend the victims impact panel. You're not to have any contact at all with the victims. You cannot write, phone, see, text, email, or communicate with them in any way. You're to serve 5 days jail credit, 1 serve 4. I'm going to have you serve all 4 of those on the court work program. So 4 days court work program, there's a $35 a day charge for that, for a total of $140. Pay fines $300, costs $350, 75 victims' rights fee, $50 justice assessment. So fines and costs are $775. You have a $60 screening fee for $835, probation fees of $300 for $1135. You have your court work program fees for a total of $1275, plus $218 in cost of recovery. Your total is $1493. You may be eligible for early discharge. If you violate probation, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. You understand all of that?
Yes, Your Honor.
Okay, and again, if you complete everything and there's no violations in the preceding 90 days, by statute, you're entitled to early discharge. You can file a petition after 7.5 months if everything's been completed and there've been no violations within the preceding 90 days. Do you have all of this to pay today, sir?
Can I work out a payment?
Yeah, how much do you have today?
I can give you a couple $100 or What's my total's 1,400 and something?
93,
I can
14.
pay 500 today.
You pay 500 now. I'll let you pay, you get paid weekly, right?
I get paid monthly.
I'll let you pay $400 a month. Is that good?
I can make that happen.
400 per month, and I'll start that beginning May the 20th. If you ever need more time, so the 20th of every month thereafter, if you ever need more time, no problem, call the court. We'll go on Zoom on or before the due date at 8:30, or you can walk into on or before the due date at 8:30. Do you understand that?
Yes, Your Honor.
You're gonna go down the hall, make your payment, you can go over to probation where they will instruct you, okay?
Yes, sir.
Anything else, counsel?
Thank you, Judge.
Have a great day.
Thank you. Mr. Gatt, listen.
Oh, yeah, he's a good man. Tell him I said hi.
Thank you.
Salaya, Rashida, Elmore. 26B150523. Morning, ma'am. Your name? All right, you're charged with driving on a suspended license. You have the right to an attorney. Would you like one?
No.
I'll go ahead and arraign you, and then I'll send you to the prosecutor to talk about it, okay? On March 19 and 26, it is alleged that you did operate a motor vehicle on Sibling near Dix, Toledo, and Brownstown at 8:57 p.m. They think you had a suspended license. That is a misdemeanor punishable by up to $500 fines, 93 days jail. Costs are all those in 2 points. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that? Yeah, and you still wish to waive your right to a lawyer?
Yes.
Not guilty, please enter $500 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand that? You understand all of that?
Yes.
Okay, so you can go out in the hallway. He'll give the file to the prosecutor. Prosecutor will call you in. Thank you. Fountain. Purnell, Lamar, Fountain.
Your Honor, I'm still waiting on my lawyer.
Okay, no problem. Who's your lawyer? Oh, Mr. Zelnick, okay. Powell, Jermaine Powell. Jermaine Powell. Jermaine Malik Powell, 24B146938 A, B, C. 24B147070A. B and C. Your name?
Jermaine Lee Powell.
Where you been, Mr. Powell?
And Moreau Mental Health.
I'm sorry?
And Moreau Mental Health.
Okay, I'm gonna go ahead and arraign you. I'm gonna give you a lawyer if you want one. Would you like a lawyer? Let's give you a lawyer.
What's this is for about, this is for Brownstown or what?
This is for Brownstown. You have a super drunk charge, you have a resistant obstructing officer charge, you have a suspend charge, and then you have Brownstown civil infractions that went unpaid from 24. I'm sorry, those are all Brownstown. Every one of these is Brownstown. 2 civil infractions that were unpaid too. So you got, well, actually, yeah, you got 4 misdemeanors and 2 civil infractions. Okay? So you go out in the hall. Who's our lawyer today?
It's a new prosecutor for Brownstown. I can't catch his name.
Prosecutor?
Yeah.
Oh, we have Mr. Robinette here for Miss Foley
Okay.
Carter
This
today.
one's going to the prosecutor. That one's going to a defense lawyer. Fountain. Oh, no, I'm sorry. Hall. People against Hall. Dylan James Hall, 25B148235A and B. Name?
Dylan James Hall.
Did you meet with the prosecutor today?
Yeah.
Let's see where he sent a stipulation in. You met with him today?
Yeah, that's like before I came back in.
Hang on one second. Oh. Good enough. Raise your right hand. solemnly swear affirming the penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, sir. I did it before the.
You solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay. You had a controlled substance charge that I placed you on probation for. You also had a possession of a concealed weapon. Since I sentenced you back on July 30, 25, have you been arrested?
No, sir.
Any new charges?
No, sir.
Any contact with the police for any reason?
No, sir.
Okay, you did have violations before, right? But you cleaned everything up, right? Right. It looks like you're compliant. You haven't had any, you don't have any other cases pending?
No, sir.
Stayed out of trouble? Case dismissed, motion to prosecutor. Congratulations. We'll send you the probation discharge papers, okay?
Thank you.
Good luck. So take everything out of lien if you would on that one, Heather.
Okay.
I don't know what I had, but that's always safe. All right. Jones. People against Alyssa Christine Jones.
She's
25B
on Zoom.
Okay, 25B148251. Good morning, ma'am. How are you? Your name?
Alyssa Jones, how are you? I'm doing well.
Good. Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you got.
Yes.
So this was taken under 771.1. It was reduced to disorderly person, public intox. Since you were arrested, ma'am, have you had, since I sentenced you, I should say, have you had any cases filed against you?
No, Your Honor.
Any other cases pending?
No.
Any contact with the police for any reason?
No.
Congratulations, case dismissed. I wish you well. We'll send you the discharge paperwork. Okay?
Awesome. Thank you so
Good luck.
much.
You're welcome. Good luck.
Thank you. You as well. Thank you so much. Bye.
Thanks. Sibwanza Bryant, Alani Antonia Sibwanza Bryant, 26B150757A and B. Morning. Your name? You're charged with driving on a suspended and invalid registration. You have the right to a lawyer. Would you like one? Okay, we'll set you up with an attorney. You can go right. Well, this will go to the defense lawyer too. Who's our defense attorney today? Okay. Robert John Gross. Robert John Gross, 2B141601. Your name?
Robert Gross.
You pled guilty to possession of a concealed weapon The plea was taken under 771.1, meaning the conviction is on your record, but it will be dismissed if you're compliant with probation at the conclusion of the probationary term. Do you understand that?
Yeah.
Before we go on, I need to remind you have the right to an attorney. If you cannot afford an attorney, I will appoint you one at public expense. Do you understand that?
Yes.
Would you like an attorney to represent you?
No.
Did you have an opportunity to review this pre-sentence report?
I don't believe so.
John, have a seat. He's going to give you that to review. I'll recall it. You tell him when you're ready, okay? Sorry about that. Thornsberry. Johnny Luke Thornsberry, 25W839358. I'm going to need Jessica and you on this one. Your name, sir?
Johnny Luke Thornsberry.
All right, so let's backtrack and let me explain everything to you. I sent you on February 4th of this year. Your plea was taken under 7411. It's a drug charge. I took it under probation for a period of 15 months. I sent you, as I said, on February 4 of 26. You pled guilty on March the 31 to a variety of counts, which I will cover with you anyway in this momentarily. Failing to pay fines and costs, which is count one. I'm sorry, count. Count one is that you were positive for a cocaine metabolite on a test of February 23. Count two, you failed to submit the testing as ordered on March 13. Count three, you failed to refrain from consuming drugs. Positive results for cocaine. Count four, you failed to submit the weekly testing as ordered on March 25. And count five, you failed to pay your fines and costs as ordered. Ms. O'Donnell, your appearance, please. So did you do an amendment on this
So
one?
I didn't do an amendment, I issued a new one, because you took pleas on the first 5 technical violations on March 31st. And then we scheduled him for sentencing today. So I did issue a new one on there that's issued with yesterday's date that has 2 new violations on there. It should be on your page. There's 1 technical and now 1 non-technical for picking up a new charge.
I don't think I signed that, did I?
No, you're not, 'cause I had it printed out yesterday.
Oh, that's okay. That's okay. Okay. Can I sign that? Do you have an original for me to
Yep.
sign? So, sir, you're also charged with failure to refrain from consuming alcohol or drugs, cocaine metabolite on April 8th, and also that you failed to refrain from violating a law. You pled guilty to possession of drug paraphernalia on April 14th in the 28th District Court in Southgate. So I'm going to give you a lawyer. I think you need one. You don't have to have one, but I would strongly suggest you have one. And then you can cover everything with your lawyer today, and then you guys can come back in front of me whenever you're ready. Does that sound acceptable to you? All right, so would you take this to Mason for me and explain what has happened? And you can follow Ms. O'Donnell there, okay, sir? And she'll set you up with a lawyer. U.S. Team Corp. 26B150589.
Yes.
Counsel, I need your appearance, please.
Yes, sure.
I need you to.
Just Chandler. Sorry.
Okay, your name?
Yeah. My name is Maria. I'm the safety manager of the company.
Where's the president at?
He's not in the office. The meeting is too early. This is why I'm appearing on behalf of him.
I need somebody to appear that's the president or at least the vice president, not a safety manager. I don't mind bending these rules a little bit on these civil infractions for corporations, but I'm not going to have safety managers or managers handling the case. The president has to be here. Can you get a hold of him?
Yes, give me just 1 second. I'm gonna give him a
Well,
call.
I'm going to ask you to have him zoom in and I'll take the plea from him, okay?
Yes, sure.
Thank
Just 1
you.
sec.
Angela Page Jefferson, 260-415-290. How are you?
I'm good.
Your name?
Angela Page.
I just don't usually see people walk up to the podium with a smile on their face. You like being here?
Not particularly.
All right, so you're going to plead to impeding traffic, right? Now, listen, you got to be careful. Your record is starting to look kind of ugly. I mean, I can do it on this one, but if you get another one, you're not going to get impeding, okay? All right, to the charge impeding traffic, responsible or not responsible?
Responsible.
All right. $180. You're all set. You're still smiling though. Why are you smiling? It's nice to see people smiling here besides me. I'm the only one who's
Points I can achieve this.
I'm the only one who smiles in here anymore, right? Have a good day. All right. Let me see here. You ready, Mr. Gross?
Yes, sir.
Come on up here. Robert John Gross, 22B141601. Your name?
Robert Gross.
All right. So, Mr. Gross, you've now read the report, right?
Yes,
Any material additions, corrections, or deletions?
unbelievable.
By the way, I got to tell you if I didn't already, and I don't think I did. You have the right to an attorney. I'll be happy to provide you with one if you would like one at public expense. Would you like a lawyer?
No,
All right. Then you waive your right to a lawyer, correct?
yes,
Is everything in this report accurate? In other words,
I believe so, yes.
okay, you read it clearly?
Yeah.
And you don't find any inaccuracies?
I believe.
Well, I want to make sure. You keep saying I don't believe you.
No.
Okay. Anything you would like to say?
No.
How come you were walking around like without a CPL?
No, you had to have CPR for a BB gun, that was my mistake.
Well, they said it wasn't a BB gun.
It says on the report BB gun.
Let me read it to you. Gross stated yes, and had advised he had a BB gun in his waistband. Oh yeah, Smith & Wesson Shield 177 caliber BB gun. That's all it was? You didn't know that? You had to have a CPL to have that?
The BB gun, no, I didn't. You can just buy them and done them, so I didn't know you had to have CPR computer. That was my mistake.
You were intoxicated or what was going on?
No, I was not.
Well,
He just gave me a
you were
ticket.
sitting on the side of the road. They say you appeared to be under the influence of narcotics and were looking around appearing paranoid. Nothing.
No,
All right. Six months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're to attend the Rights and Responsibilities Weapons Program through Class A Training Center. Okay?
yes, sir.
And you are still working at Ford?
Yes.
All right. Remember, 24 hours of community service. You have to have that completed by, I'm going to give you until June the 15th. 24 hours community service, any nonprofit organization. There is no proof other than that statement. I'm not going to guess. I'm not going to order abstention, but if you're using something, you better get yourself some help. 3 days of community service by June 15. You're not to possess firearms. You're not to possess dangerous weapons. Again, you're to attend the Rights and Responsibilities Program through Class A Training Center. You're to pay fines 100, costs 100, 75 victims' rights fee, $50 justice assessment. Probation fees are 120. So your total there amounts to $445 plus your screening fee of $60 is $505. You pay that, you stay out of trouble. You do your 3 days community service. You'll come back. I'll give you a review hearing date, and if you're compliant, the case will be dismissed. Okay?
Yes, sir.
So Heather, what do you have in terms of a review hearing for me? If you violate, you could get 90 days. You understand that?
Yes.
And the 771 status revoked and conviction would remain on your record. You understand that?
Yes.
Okay, so it should be what, Heather? Early October?
Yes, Judge, we can do October 7th.
At 8:30 in the morning, October 7th at 8:30 in the morning. Can you pay all your fines today?
No, I can pay like $100 a day. And I get paid tonight, so
When are you gonna pay the rest then?
next week?
You sure?
Yes, sir. What's the total right now?
505. You pay 100, you'll owe 405.
Yes, sir.
By next Friday?
Yes.
So that would be on the 20, well, don't come in next Friday. It's gonna be kind of packed in here. We got law days, so you don't want to be coming in here that day. I'm gonna give you until May the 4th to pay everything, okay?
Yes. Sir.
You'll go down the hall, pay your 100. You'll get your notice giving you your review hearing date on October 7th. Then you're going over to probation where they'll go over with you, okay?
Yes, sir.
Best of luck to you. Thank you.
So you all know, if you've followed me long enough, I am unapologetically 2A. So the concept of needing a CPL to carry a BB gun blows my mind. You know, I left Michigan behind almost 20 years ago now with no desire to return, and that kind of solidifies it for me. 29 of the 50 states now have gone constitutional carry. In other words, you do not need a permit to concealed carry a firearm. So the idea that Michigan wants you to have a CPL for a BB gun just does not align with the national trends for sure. But that's what I think. You let me know in the comments, if in the chat rather, if you feel differently. Let's go to Florida. Wade Mercer.
Count of fleeing or attempting to elude, 1 count of reckless driving, and 1 count of driving while license suspended. These are old charges. My understanding from the complaint is that when these charges happened and the same day after you allegedly fled in Jackson County, there was an accident in Alabama. Someone passed away and you were actually sent to prison in Alabama. Is that correct?
Yes, sir.
I think it was the same continuing incident
Yes,
from
sir.
traveling through Jackson County into Alabama. It was the same incident though. So, Mr. Lutz, when did you get out of prison?
Last year in June, I believe.
There's a 26, a May 5th of 26 escape in Shelby County. May 5th of 26, excuse me, April 5th of 26, which would have been 2 weeks ago in Shelby County, Alabama. Is that charge pending?
No, that is where they picked me.
That's a fugitive charge that they're.
Where they picked me up for this.
Okay. And then there's an August 14th of 24 violation. That's where you allegedly violated terms of your parole or something, correct?
Yes.
Did you get my text message? I did. I think that's the same thing. So I think the way I'm reading this, you haven't been charged with any new crimes since you got out of prison. Is that accurate?
No, sir. Yes, sir.
Okay. All right. I just want to make sure I'm reading it right. It looks like there may have been a violation of something about drugs in your system. Mr. McDaniel explained that. And then the escape is actually the warrant from another state. So you've been in jail a couple of weeks in Alabama waiting to get here. Is that correct?
Yes, sir.
Okay, fair enough. Let me see if the attorneys have any additional information. Mr. McDaniel, anything?
Just take that information in. With the court.
Okay,
We just
Mr.
asked about reasonable release.
Thank you, Mr. Mitchell.
We just request the reasonable standard bond for the charges that he is.
So, Mr. Lutz, these are 2007 cases. And I understand that you've been to prison for something allegedly occurring the same day or when Florida was known as the same criminal episode. So that's a factor. How long was the actual prison sentence? I'm not asking how long you served. What was your actual sentence?
18 years.
That's how much you did. What you sentenced to?
That's 18 years.
Oh, you had to go 18?
Yes, sir. Because remember, I got out 1 year before prior.
Okay. So given all that, I'm going to those are factors that the judge and your attorney obviously need to know when you get over to felony court on this. I'm gonna set you a $5,000 bond on the felony charge, $2,500 on the misdemeanor. Actually, I'm not gonna do that. I'm gonna tell you what I'm gonna do. I'm gonna do a $5,000 bond on the felony. Mr. McDaniel?
They didn't file an information on the misdemeanor. It
Yeah,
was only
that's what I'm getting to, yeah. So I'm gonna set a $5,000 bond on the felony, and I'm gonna give you an RR on the 2 misdemeanors. And let me explain why. The state asked for a warrant on all 3 charges. Actually, yeah, they asked for a warrant on 3 charges, but then the prosecutor only charged you with the 1 second-degree felony, fleeing and looting. So the other charges technically have not been filed against you, and they've been sitting there for almost 20 years. So I don't know if the state can go forward on those or not. So I'm not going to ask you to require you to post a bond on that. You've got the 1 bond to post on the felony. And Mr. McDaniel, I'm not familiar with these situations. This may be a conflict for your office because of who the prosecutor was.
It probably will be. I'm gonna let him know.
Okay, fair enough. So Mr. Lutz, you've got the right to post a bond. If you post a bond, you'll be released. You'll get to use the phone in a few minutes. Your court date should be May 5th at 8:30. Any questions, sir?
No, sir.
And I suspect
Have a good day, sir.
if the state actually proceeds with the case, because nothing's gonna happen until they get it. But there is an information file, so there's, so, yeah. We'll have the conflict. Cash bond. I doubt it. Judges, just surety bonds only option.
I think given severity of the charges and also what happened in the same event, we would just be requesting a standard surety bond.
Yeah, I can't set a surety bond unless both sides agree. I'm a cash bond, so it's a surety bond. I said 5.
Yes.
And RO on the other 2 that haven't been filed.
I was thinking the exact same thing about that's probably a conflict automatically.
All right, good luck to you.
Mr. McDaniel, that's everything I had on my first appearance list for this morning. Anything else from the public defender's office?
Nothing else, Your Honor.
And
short morning for Wade Mercer. Let's go back up to Michigan. Judge DeSanto.
Your Honor, good morning. Richard P. Serrano, P33828, appearing on behalf of my client, first on the right. This is the date time set for a show cause matter. Sir, please state your name.
Antonia, Leslie. All right, good morning, sir. Thank you for dressing appropriately for court. Today's date scheduled for show cause on your client's lack of payment on the $1,756 he owes from his conviction of disorderly conduct back in 2023.
That's correct, Your Honor. And my client says yesterday he made a payment. What did you bring in yesterday, sir?
I made a payment on Monday.
And what was the amount of that?
$30.
And the court may recall he was placed on a payment program. He is aware that he still has obligations, although he completed the probationary period. The monetary amounts have to be taken care of. He's aware of that. He has an additional $25 today. The reason, Your Honor, the payments are in the lower range is because he is presently the only employment he really has, if you want to call it that, is he's a caregiver for his grandmother who's present in court. He also is, to support himself, he's had to donate blood. Right now is the reason why is because recently at Columbus restaurant where he was a dishwasher server closed down. So that's how he lost his employment.
You were just instructed, all phones have to be off. Step out into the lobby, please, now. Out into the lobby. All phones are to be off.
We apologize. That's his grandmother.
Okay.
So, Your Honor, he wants to continue to make regular payments and we will pay as much as he can, but right now that's all he can afford. He's obviously here. Some people just forget about it and never show up, but my client has shown up each and every time, so we'd like the court to consider that.
Okay, well, sir, when did you fall off on your payments?
When I lost my dad.
Okay, and have you been applying anywhere else for work, sir?
Yes, ma'am. Yes, Judge. I just did an interview for Hopcats
Okay,
For host.
okay. All right, sir. So here's what I'm going to do. You made a $30 payment yesterday.
Monday.
Oh, Monday, sorry. Yes, you said that Monday. All right, so can you commit to $30 per month at this point?
Oh, 5, you okay?
25, yes. All right.
And he's making a payment of 25 today. I told him you can pay online as well as come in.
Okay. So then what we'll do is we'll indicate that payment plan will start today then. Okay?
Yes, ma'am. Yes, ma'am. Very much.
Okay. All right. So, then just, you can get information as well, sir, about paying online at the window. And, sir, in the event that you're unable to make a payment, please email into the court. Okay, to let us know what the situation is. If, when you don't email and you don't communicate, that's when you have to come back to court. Okay?
Understood.
All right. Have a good day, sir. Thank you.
Thank you.
All right. And we are on the record in the matter of the, you're welcome. The state of Michigan versus Jose Jimenez Gonzalez, 241321. Mr. Gopal?
All right, well, they sort out who's going to be up next. Let's go down to Texas because we haven't been there all week. Nobody's been up and running really. Well, we went to El Paso, so I guess we did go to Texas, but not like the big judges. But Judge West is up and running this morning, so let's say good morning to her.
You get someone hired?
No. No.
So who did you talk to?
Actually, you told me it worked, so I started applying for the jobs. I got sitting here at 2 o'clock.
Take your hands out of your pockets. Speak where I can hear you.
Sorry. Told me I couldn't do posters anymore, so I've been applying for the jobs.
Okay,
Second interview today at Home Depot at 2 o'clock.
okay. All right, so what I'm gonna do this morning, Mr. Gray, is have you fill out some paperwork to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk on the end and she'll give you that paperwork. And Brittany Davis. Brittany Davis, I'll recall that on forfeiture. Good morning, ma'am.
Good morning.
You're Brittany Davis?
Yes.
And Miss Davis, were you able to get a lawyer hired?
I talked to Jeff Todd, Neil Davis, and Corey Huff. So 3 of them is looking pretty good.
Okay, where are they located?
In Houston,
Okay.
County.
And so where are you on being able to get one of them hired?
I was hoping for if I can request a bond reduction. Cause it's kind of hard paying the bondsman.
I typically don't, once you've made bond, reduce the bond. I have before. Look at something real quick. So you made a $10,000 bond?
No, they pretty much took a portion because I have a.
Right, but that was, I mean, that was the amount, that's your bond amount, and then they made you pay part of that, correct? So
yeah.
your bond was at $10,000 on what you're charged with, I think is reasonable. I'm not going to reduce that.
It was $100,000.
Did you miss court? Oh, did you test positive in court?
With the patch.
Yeah.
Yes, ma'am.
You still have the patch on?
Yes, ma'am.
So the patch. February was positive. Have a seat in the jury box. Let's get you tested this morning. Make sure you're clean. Roderick Guillory. Good morning, sir. You're Roderick Guillory?
Yes, ma'am.
And Mr. Guillory, were you able to get someone hired?
No, ma'am. I have agreed to get.
Who'd you talk to?
I talked to Gertz Kelly Law Firm, and she said I had to pay $5,000 now and pay for the rest. And Wayne Walker,
Mm-hmm.
and I guess she said it was just some call worker as well.
Right.
And I was trying to see maybe if I can try to get a report.
Are you working?
Yes, I just started working.
Where are you working?
I work at Goodyear.
Okay, so why don't I do this? If you just started working, it's are you what are your hours
I
gonna
work Monday through Thursday.
be? Okay,
Today, so 40 hours.
40 hours. Okay, and what is your rate?
$22.
You're probably, now that you're working, I don't know that you would qualify making that amount. You might, but let's let you, I'm gonna reset your case one more time. See if you can get some money saved up. Talk to some other lawyers. So if you get someone hired before the next court date, same thing applies, bring that that you get to them. But if not, talk to 3 others. You can tell they all charge different amounts and stuff. So talk to them, bring me those names. Also bring a pay stub in with you. And if you haven't been able to hire someone, we'll talk about you filling out that paperwork, okay? All right, step in front of the clerk. Akaya Nash. Good morning. Are you Akaya Nash? Yes. And Ms. Nash, this is your initial appearance and cause number 26 DCCR 0206. You're charged with a 2nd-degree felony offense of aggravated assault with a deadly weapon from November 23rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I can, but I haven't because I just started working.
Sure. Okay. So what I do, Ms. Nash, I'm going to reset your case about 30 days to give you some time to try to get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering that you visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options if you need more time or things like that.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you will go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you a reset notice. Yeah.
Nuts.
I still think this is, understand. Okay. Darian Broussard. Good morning, you're Darian Broussard. And Mr. Broussard, you're on misdemeanor probation. Answer yes or no.
Yes, ma'am.
And it looks like I've gotten some information that maybe you've been testing positive on that probation. Have a seat in the jury box. I'm gonna get you tested this morning. Corbin Rayleigh. Good morning, sir. You're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, were you able to get someone hired?
No, ma'am, but I brought some pay stubs like you asked for.
Okay, let me see, that. Hand it to the back.
The right side.
Okay,
I've been making sure to get them every week.
okay, perfect. So you get paid, each week?
Yes, ma'am.
Okay. All right, so what I'm gonna do, I appreciate you doing that. What I'm gonna do this morning, Mr. Rayleigh, is have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct. So put that income in, whatever your bills are and things like that, okay? Step in front of the clerk on the end. Real docket and next to it. That's.
All right, I will keep an eye on Judge West. Let's head back up to Judge McNally for now.
Am I right?
Sir.
State your name for the record. Prince Dozen.
All right, so you're standing in for Mr. Dubin,
That's true.
and you grant him permission to do that, correct, Mr. Idiuzu?
Yes,
Am I pronouncing that correctly?
Edo.
Idozu, I'm sorry. So, Mr. Slavin, as I understand it, your client is going to plead guilty to operating while impaired. The super drunk charge will be dismissed on motion of the prosecutor. And also, he is going to plead guilty to resist and obstruct an officer under 771.1 with the urinating in public to be dismissed, correct?
That is correct. He's pleading no contest. He got alcohol content, but he has a memory shaky at best. He had advised of his rights, and then he did sign the best rights in the package.
He didn't indicate a no contest plea here. I'm not saying I wouldn't take it. You don't remember this incident, sir?
Oh, Your Honor.
So there's a lack of memory. Okay, so I will go ahead. Need to find the police report here. If you plead no contest to the charge of operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs are all those. 4 points. You know what? I'm getting ahead of myself. I don't even see a police report in here.
We will stipulate that the blood alcohol content, those the usual, so they set the,
Yeah.
this crime lab came back with 0.29. Maybe it's so stipulated that I basically.
John, go find out. He needs to answer that.
Hello, this is Dean.
Mr. Robinette, can you send me in a police report on Idozo here, Prince Idozo? I don't have a police report in the file.
Judge, I'll have that right into you.
Thank you.
Sixth judge will be right there.
Okay. So let's start here. If you plead no contest to the charge operating while impaired, it has the same effect as a guilty plea. The possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs, or all those. 4 points would be added to your traffic record. Your license would be suspended or revoked in accordance with your record. Do you understand that?
Yes.
And if you plead no contest to the charge of resist and obstruct an officer, the possible penalties are up to 500 fines, 90 days jail, costs for all of those penalties. You understand that? And again, you understand that a no contest plea has the same effect as a guilty plea.
Yes.
You got to keep your voice up.
Yes, sir.
And you understand if you plead no contest on the R&O, the resist and obstruct, then I'm going to take it under the provisions of section 771.1. I'll put you on probation. If you're compliant, at the end of the specified period that I set, the case would be dismissed on motion of the prosecutor. Do you understand that?
Yes, sir.
All right. And did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead no contest, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, Your Honor.
Okay. We're gonna, and you stipulate I can use the police report to us. Bring it right up here, sir. Who are you?
I'm, my name's Tony, I'm the law clerk for D.
Okay, good to have you here. All right. So do you stipulate I can use the police?
That stipulation's correct.
All right, so by stipulation, I'm gonna have that marked Peoples 1 and I'll review it. To the charge of operating while visibly impaired, how do you wish to plead?
No contest.
To the charge of resisting obstructing officer, how do you wish to plead?
No contest.
All right, give me 1 second. We're gonna have that marked. I'm gonna review it and we will go from there. Something bothered me here. I can tell you that. I ordered 3 times. Does he have prior drunk drivings?
No.
It was just as a result of the wood. All right, let me just double check
I think
this.
what might have been the situation factually, at least from my arraignment, is that there was urination in public. He was in his driveway, but he had asked a couple of times to go in the house. But obviously, they have to keep an eye on to make sure that no one consumes alcohol or does anything that might impede the investigation. So instead of just urinating himself, he urinated on his driveway, which is a situation I think is memorable anyway.
Right. All right, I've reviewed the report. There's a factual basis for both the pleaded with operating while impaired as well as RNO. Are you on probation or parole?
No.
Anybody force you to plead no contest?
No.
Anybody promise you anything other than a dismissal of the urinating in public and the super drunk charges, if you plead no contest?
No.
Okay, I'm gonna accept your plea of no contest to the charge of operating while impaired, dismiss the super drunk on motion of the prosecutor, accept your plea of no contest to resist and obstruct an officer. I'll take that under section 771.1. I'm gonna refer you for a screening and assessment. We're gonna give you a sentence date. I'm also dismissing the urinating in public charge on motion of the prosecutor. So we're gonna give you a sentence date. You're going to go down the hall, get your notice, and then you'll come back for sentence. So what do you have for me, Heather, for sentencing?
We can do May 6th at 8:30.
Is that good with you, Mr. Slavin?
That works.
May 6th at 8,
Myself and Mr. Dugan.
that's fine. May 6th at 8:30, go down the hall, get your notice, and then we'll see you back here, okay? But you're gonna go across the hall and fill out a questionnaire and be interviewed before you leave. Any questions? All right, good luck. Thanks a lot. And he has been going AA, right?
It's just gonna, he was, wanted to show you that he's got all the signatures you wanted.
If you've seen him and he's been going, no problem. I don't need to see it. Thank you very much. Jermaine Malik Powell here. Who's your lawyer, sir? Mr. Gaith?
I think that's.
You want to, well, we have to get him in here first. Just wait 1 second. You have a seated right at the table there, okay?
He said it's gonna be bad.
Okay. Go off the record.
All right, since he's off the record, we're going to do something fun that just popped up. This is a special stream from Judge Middleton where he is explaining the courthouse that he is in. You know, we went through that on the pre-show, but let's hear it from him.
Good morning. Today is the 22nd of April, 2026. Tried to make this record yesterday, but we had some technical difficulties when we first started our morning. I'm in the historic courtroom in the St. Joseph County Courthouse. And yesterday, April 21st, was the first day that district court proceedings had ever been held in this courtroom. And it's the first day in many, many years that any court was held in this courtroom. This courthouse was built in 1900. They started in 1899. The cornerstone was laid, and the courthouse was dedicated in August of 1900 and started to hold court at that time. The courthouse contained the circuit court and the probate court. There was no district court at that time. And the circuit court was shared with Branch County, at least Branch County. We didn't have a St. Joseph County circuit judge. We had a St. Joseph County probate judge. The circuit judge served in 2 counties, and it was originally Theo Jacobs, at least in this century. There were some others before that, but into the like maybe 30s, the last 100 years. Judge Theo Jacobs, Judge Mark Andrews, Judge Robert E.A. Boyle, who presided in this courtroom when he was first elected. Judge James Noecker, Judge Paul Stutzman. That is the circuit court chronology. And this was the circuit courtroom. The new courthouse, well, there was an earlier courthouse on this spot in the village square in Centerville. It was built in 1842. Michigan became a state in 1831. I think Centerville was incorporated near that time. In 1842, a courthouse was built on this grounds. We have some pictures of it. There's a mural of it in the hallway that was painted by someone in the 20s or 30s. It had 2 outside restrooms. At any rate, that building was torn down, and this building was built, as I said, in 1900. It served as the county courthouse for all of that time, and till the early 70s when there was an effort to build a new courthouse. And that is what has become to be known as the Courts Building. And that is located immediately adjacent to this. It's a big square box they plopped down there and opened in 1975. Held all 4 courts: district court, probate court, circuit court. There were only 3 judges at that time. And this courtroom was closed down in 1975. So there was one trial in here that I conducted when I was prosecuting attorney in the mid-90s on a pyramid scheme case. We had a visiting judge from Van Buren County. He said he would come if he could try the case in here. And so we did, and I tried the case according to the Attorney General as the first pyramid scheme case that had been tried in Michigan in anybody's memory. Defendant was convicted. There were 2 of them. Anyway, Judge Stutzman, a time or 2, did jury selection in here in large cases, murder cases that required lots of jurors to be brought in. So they did use the courtroom. But from 1975 to 1995 or 96, this room was all in disrepair. The roof leaked. They had some 2x4 offices built in the back. It was in very poor condition. And a previous county commission decided in the 90s that they would refurbish this historical court building. And they did an excellent job. They had a good plan. They set up a shell building, and they moved all the county staff that was housed in this building to that shell. They completed the construction. They were very careful with historical accuracy. The wallpaper you see behind me was actually hand painted by the ladies from Three Rivers Floor Cloths. And there are a number of their pieces of artwork here in the building. There is a judicial seal up higher. You can't see it. It's also stenciled on the wall. They did meticulous care with restoring the old furniture. I'll show that to you in a little bit. The original courthouse chairs were all taken and professionally redone. And this was then used as the county commission chambers from 1995 or so. 1995 until present day. The county commissioners use this as their meeting space, and it is a appropriate space for that use. The courthouse that was built in 1975 is now more than 50 years old, and it is in shabby state. So the county commission once again decided it was time to refurbish it. So in the last 4 years, they bought a building in Three Rivers, and they refurbished that, and they moved the probate court friend of the court and some other county services to Three Rivers. And now they are refurbishing what was previously known as the courts building. It's going to have better security, better plumbing, better mechanicals, better everything. It will be essentially new, $12.5 million. And it's a ghost town full of activity over there. All the officers are stripped bare, dirty carpet, dirty walls, water's turned off. The workers are over there now and working on it. They did hang my nameplate on this bench, but it's hung too low for anybody to see it. So maybe we'll pull it up so it's visible to the members of the audience, but not on the camera. So in order to facilitate the construction of the courts building, it was determined by the commission, by the builders, by the building manager that it would be better if we can completely empty that building. So it would go faster and be easier to do. And then it turned out where they really couldn't do it unless everybody was out of there. So I got a higher chair. I felt like I needed a booster seat, but I think we're going to agree this one will be adequate. So Judge Pattison and I will be sharing this courtroom as a district courtroom. We also have a very small hearing room, which is outside of Judge Pattison's office. And he is operating out of there, and we'll both be sharing it. We both have offices on this floor. What was previously Judge Boyle's office behind me is now the jury room. In the days this court was used, it was certainly a different time, same place, but different time. The lawyers would come into town for the terms of court. In those days, and even when I first started in 1980, the circuit court ran on terms. They had a January, April, July, and October term of court. And they would call all the cases on the first day of the term of court. The lawyers would come into town, many of them on a train from Sturgis to Wasippi, of all places, which is really in the middle of nowhere. And then they would take a carriage from Wasippi to the Centerville House, the hotel that's kitty corner from the court square. And they would stay there, and then all the lawyers would come in and they would start to conduct their business. As I understood it, it was everything. Civil matters, criminal matters, divorces. They would address them on the first day of the term of court and maybe schedule what needed to be done after that. And those were the lawyers that were here before us. Most of the lawyers that practiced here have passed away. Our two senior members of the bar are Pat O'Malley from Three Rivers and Howard Bush from Constantine. Howard was born in 1941. I believe he actually may have practiced in this courtroom. Judge Noecker was a prosecutor in this courtroom. And many of our attorneys that preceded us, like the Ray Dresser Sr., who was president of the state bar, Rotary governor, practiced in here. Ray Dresser Jr., who was a fine attorney in Sturgis, practiced in here. Leonard Weiner, Dick Wade, Leonard Bullard, the attorneys that preceded me, they'd all be over 100 if they were still living. They practiced in this courthouse and this courtroom. And things were certainly more genteel then. They didn't hold court in the summertime. It was too hot. They didn't have any air conditioning. So if they could avoid it, they didn't try any cases in the summertime. Judge McManus came to St. Joseph County in, I believe, 1963 from Lenawee County. And he became the county prosecutor. He was young at that time. And when I took over as prosecutor's office, he had a box that said felonies, 1963 to 1969. had about 20 cases in it. The whole box held 6 years worth of felonies. Well, it's a different world that we live in today. And it was gentler and quieter, but not always, because you could go to prison for things like stealing something out of somebody's garage. It was a harsh time too, particularly if you were of color. The district court was created by the Michigan legislature and courts. I believe the Constitution of 1969 created the district court and did away with the justices of the peace. So they had to find a place for the district court, which was what's now in the historic room. All of my staff, Judge Pattison and my staff, is now housed in that room. It's full of books on shelves. They did carpet it to protect the floor. And for the next year and a half or so, they'll be operating out of there. There were some famous cases tried here over the years, homicide cases, and we didn't have very many, maybe one every several years. And there was a homicide here in Centerville in the 60s that I think that was tried in here. There was a famous case from Detroit that was tried here in the 70s, about 1972, maybe 71. Anthony Giacalone, who was at that time believed to be the head of the Detroit crime family, had a change of venue. I believe he was charged with possession of a bludgeon, which is an obscure statute that encompasses like a blackjack or a sap. He was charged with that, and the venue was changed, and they sent the matter out to Centerville to be tried. And somebody came either from the Wayne County Prosecutor's Office or the Attorney General's office. And I think Judge Boyle tried it. Well, maybe he wasn't here yet. Anyway, maybe they brought a judge from Detroit. Anyway, they had a trial, a jury trial in here regarding Anthony Giacalone and his possession of a bludgeon. And I believe he was convicted. Anyway, that's the history that precedes me and precedes Judge Pattison and precedes everybody that's going to follow. So it's certainly going to be a inconvenient time while we're all crammed into a small amount of space for the next year and a half or so, maybe 2 years. But it's a privilege to be in this historic courtroom where people that practiced before me, lawyers, judges, prosecutors, defense attorneys, people I knew, Michael Gergley practiced in this courtroom. Cordell Jones, Judge McManus, many of the older lawyers that I had a lot of respect for practiced in here. So now it's our privilege to be able to utilize this courtroom for the next couple of years while they modernize and securitize our old courtroom. This courthouse is not very handicap accessible. It's not particularly user-friendly in some aspects. There's only one small elevator and the steps are quite steep. And, but we're going to do it for the next several years. My tenure will end on December 31st. It will be somebody else's turn. And the filing deadline to file for a 3B district court judge was yesterday at 4 o'clock. So the only person to file was certainly a qualified candidate, Mr. Tim George, who has support of all the other 4 judges, has been designated as the only candidate for my seat. So it certainly appears that Tim George is going to be the judge to succeed me, and he has my support. So I'll try not to make too much of a mess of things for him before I go. Anyway, I wanted to give you guys a little historical sense, and anybody can watch this for anything. I'm going to take my camera and I'm going to turn it around. You might not want to be in this shot. I'm going to show what the part of the courtroom that you can't see looks like. You see a portion of the courtroom. They've got that screen over there. So they've got ugly tech mixed with historical context. There's also too many chairs in here. There's boxes of stuff. We're still working on it. I'm going to take the camera and let you see the part of the courtroom that you can't see.
Oh, wow.
Not working. Maybe it's a bit of a delay. They've hung the pictures of Judge Welty and Judge McManus. There's what is going to be the jury box. There are the windows that shine in here. It's hard to do this because it's not on real time, but that is the part of the courtroom that you can't see. And behind that, to the right of that picture, is where the jury room is. So I've got lots of bright windows, lots of sunshine, and it'll be hot in the summer and cold in the winter, I suspect. We did not have any other court today, at least I didn't. This would have been a jury day, and we didn't schedule any jury trials because of the move. I have jeans and a work shirt on. I put a tie on for this purpose, but I'm moving finally to get completely moved in. I brought Tim George in this morning and said, here's what your office is going to look like. And I wish him all the best. So for the next 8 months or so, we'll be in here. Judge Pattison and I will be sharing it. From time to time, I will be using the small courtroom. See how that goes. And so thank you, everyone. I let the comments run. Prisoner transport is not ideal. You'll be seeing some as we work through our issues. This is only the second day we've been here. We're working on it. And maybe I'll talk about some of the other questions later, but anyway, that is that's it. All right, I didn't make a record of this, just the YouTube video. All right, thank you all for taking your time. I don't expect to be back on the record today because they didn't have anything immediate custody. Tomorrow, I'm going to Berrien County. I'll be at the Niles Courthouse on a case that I was specially assigned to in that county, and I'll be back in the afternoon for our court. So thank you all. Everybody have a good day wherever you are. And I did have a first line, but I guess we'll save it for tomorrow. All right. For those of you that live here, maybe that's a little historical update. For those of you that don't, that's a little visit to the county courthouse in St. Joseph County, Michigan.
So I hope you all enjoyed that. Some people didn't. We shed viewers during that, but I think it was totally worth it. They don't make them like they used to, do they? And that's not just buildings, that's also judges in a lot of ways, isn't it? You know, we've seen Timothy George in Judge Milton's courtroom. I don't know a whole lot about him. I don't know his position on streaming. So I'm going to do a little bit of homework since we know that's going to be who's replacing him since there's only one candidate. But I really enjoyed listening to Judge give the story of that courthouse. It amazed me, as it did somebody else in the chat, that he did all of that from memory. He did not have notes he was reading off of, so that was impressive. And that building is just stunning. We need our culture back. If I may just for a minute get off on a tangent. We stopped building culture. I mean, real culture. And we need to really get back to that because it's what makes us who we are. You know, we've talked about this in other spots. Maybe it was on Sidebar once, but I'd mentioned, and this is true, you know, the same contractors that build schools and hospitals and all of that are the exact same ones that build prisons. You know, it's just the same standard concrete box that's just built over and over and over again. There has to be a beauty to things. There has to be an art to things. And that's why I love buildings like that, and I really wish we'd get back to it. And, you know, I appreciate the fact that Judge Middleton has an appreciation for those things and took the time to tell the story so we all understand the space that he's occupying now. And I mentioned this yesterday. I think this is the best way for him to finish his career, to be in that courtroom. The older judge who appreciates where he came from, going back to kind of where it all began in that area, I think it's just poetic. Anywho, enough of me. Let's go back to, well, let me find where we can go. Let's do this. Let's go back to Judge West.
It's been a long time.
It does, doesn't it? Good morning. Good morning, sir. You Alan Lua? And this is cause number 26 DCCR 0256. Mr. Lua is charged with possession of a prohibited weapon. And what is the announcement?
Your Honor, Mr. Lua has a pending federal case, which is the same, and I'm working through the discovery in it, which will result in a plea at some point.
Okay.
I'd ask that this be reset. However, according to their schedule, they would have it all set for June 1st, but I don't think I need that long.
Yeah, I know. I mean, would it be your intention to wait on what happens over there as well?
Yes, ma'am.
So why don't I do this? I'm going to reset it 90 days.
That'll be fine.
And I know that process takes a while. We'll see where you are in that process once we get there. So make sure you stay in touch with Mr. Macon, take care of everything you're supposed to with your bondsman, and over in federal court. We'll see y'all back in 90 days.
Thank you.
All right. Thank you.
Good.
Get all that money.
I can get some more DAs. You did? Is Mr. Nichols coming down today? Okay.
He's in a jury room, Judge.
Is his client gonna be here? David Hatcher?
There's the Nichols.
Morning.
Morning.
I'm not sure if Mr. Hatcher is gonna be here just because Mr. Gertz had already said he could not be here today, but announced ready for trial. What's your announcement on that?
No response, no.
All right, I'm not gonna forfeit. I think they probably told him not to be here, so it's Mr. Gertz's.
All right, that close-up of that guy's hands is just absolutely amazing. But that having been said, not good for the podcast side. So let's go over to Judge McNally.
24 incident. I also have 24B146938 A, B, and C. And those emanate from the same date, it looks like. Appearance?
Judge, I can get that, Mr. Powell stated his full name.
Right,
For arraignment purposes, Judge, we'll stand in with agreement.
All right, I'm entering not guilty, please. I need to check into this one. All right. Where's he been?
Judge, after the incident, Mr. Powell began to have issues, namely the mental health issues, and he was in treatment, he was committed to the hospital for a period of time, Judge. It's just now that he's been able to get back on track. He's actually, as a result of this, had to apply for SSI as well.
What was the blood or breath result allegedly? Don't tell your lawyer.
Judge, he refused the PBT. He was ultimately taken to the hospital. I didn't see what the,
They charged him with super drunk. Here's what I'll do. He's posted surety bonds. If you miss again, we're gonna have a big problem. No contact with Officer Washburn. So I'm continuing all your surety bonds. You got 5 of them, but you got to come up with some money on these civil infractions. They're old. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No contact with Officer Washburn or prosecution witnesses. You're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. You're to attend AA, NA at least 2 times per week. I want you to go in person, okay? So he's going to hand you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you, okay? You're not to possess firearms. You're not to possess dangerous weapons of any kind. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand that, sir? Yeah. All right, so we're going to give you a pretrial date. You're going to have to fill out. Actually, you're not working, right? No? I just need you to fill out a petition, and I'm going to set a pretrial. I'll give you a court-appointed lawyer going forward. What are we doing on this one, Heather? Is it going to be the 6th?
May 6th at 10 o'clock.
Okay, so May 6th at 10 o'clock will be your court date on all these, and you still live on Stewart Road?
Good.
So that will all be taken into account, and we'll go from there, okay? So listen to me. You're going to go down the hall and get your notice, but first you're filling out your petition for a court-appointed lawyer, and you have to come back May the 6th, all right? Best of luck to you, sir. Brian, which one do you have?
Mr. Griner.
Brian Shane Griner. 2-5B-149-713 A, B, and C. And I also, wait a minute, I have one, hang on one second. I have 9713B. I have 25B-149-678 A, B, and C. Okay, go ahead, counsel.
Good morning, Judge. Mr. Griner states his name.
Brian Shane Griner.
So he's going to plead guilty to the added count of no operator's license on person.
Correct, Judge. As well as the careless,
Pardon?
as well as the careless drivers, the HR.
I got it. So the no ops he'll plead to, the suspend's going to be dismissed, and then he's going to plead to careless, and they're going to dismiss the,
Stop.
he did not, and they're also dismissing the drive while suspend, right?
Correct.
Wait a minute. What about this other one, the left center accidents? He didn't address all of it.
That's the show cause, Judge. Mr. Griner was pretty guilty of sales of pay on that. And then he did also pay off the expired plate. The expired plate ticket, he did pay that.
So the careless is going on the,
Still stop.
all right. If you plead to careless driving, sir, that's a 3-point civil infraction. Do you understand that?
Yes, sir.
If you plead guilty to no valid operator's license on person, that is a possible penalty as follows: up to 100 fines, 90 days jail, costs, or all of those penalties. Do you understand me?
Yes, sir.
If you plead on those two, I'm going to dismiss the suspend. I'm going to dismiss the leave the scene charge, but you'll still have to deal with the left center accident and no proof of insurance show causes. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all of those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge of careless driving, by the way, you understand that's 3 points.
Yes, sir.
To that charge, do you plead responsible or not responsible?
Fine.
To the charge, no valid operator's license on person, how do you plead?
Yes, sir.
Were you operating a motor vehicle in Brownstown Township on November 15 of 25 on Dix near Sibley in Brownstown?
Yes, sir.
And did you have a valid license with you on your person at the time?
No, sir.
Are you on probation or parole?
He is.
Were you on probation or parole on November 15 of 25?
No, sir.
So he was not. So this would not be violating another probation. Has anybody forced you to plead guilty?
No, sir.
I'm gonna accept your plea to careless driving. Accept your plea to no valid operator's license on person. I'm gonna dismiss the leave the scene and the drive while suspend on motion of the prosecutor. He owes 285 on 78C and he owes, I think, Heather, you can correct me. He owes 282 plus a clearance fee on 713B, right? Is that
am
right?
So 7-8C, he owes 285. And then the other one, I'm sorry, was that 13B you were looking at, Judge?
713B, it looks like he owes 282 plus his clearance fee of 45. That's a no insurance charge.
So yes, 327 total. That's what the clearance.
282, 570 you owe plus 45 in the clearance. Can you pay all of that today?
Yeah, Mr. Griner's had some medical issues. He broke his back. He's been there for a long period of time, Judge. So he's gotten no income at this point. He also has another issue out of Monroe, which he was ordered to pay on. He owes $1,300 on that. And his finances are extremely limited at this point.
How long you been out of work?
Couple years.
How did, you broke your back?
Yeah, I got 3 ruptured disc, my all 3 vertebrae broken in 3 places.
How are you supporting yourself?
But tough, I just odd jobs, little yard cleanup, cutting grass, odd jobs when
I'm gonna do this. I'm ready to sentence him and we'll go from there, okay? Anything you'd like to say on his behalf? Let's just talk about the careless driving and the no ops.
Just that, Mr. Griner understands that he needs to get his situation taken care of with the licensing. And again, Judge, it is a financial issue, that's preventing him from being able to get his privileges reinstated. As far as the careless driving, Judge, he did, it was amended down, but originally there was an accident that was involved and I did speak.
Was that with another vehicle?
No, Judge, he hit a light, he lost control, hit a ditch, and then he hit a light pole. So there was no other vehicle that was involved.
How'd you manage that?
lost control.
Why'd you lose control like that?
He doesn't recall much of what happened, Judge, because of the initial impact. So his memories pretty limited.
Pretty hard to.
As to what happened before and after. He took a very bad hit from the airbag to the face. And that's caused.
And then you left the scene.
Well,
right? Did you leave the scene? He left the scene, right?
Judge, that's disputed. That's the reason why they were willing to work with us on this, because there's a question of fact there as to what.
Why did the police officer? Hang on, slow down.
Judge, according to the report, when the officer arrived on the scene, he didn't see Mr. Powell, Mr. Griner, I apologize, at the vehicle. However, Mr. Griner was still in the area, and when the officer called him back, he did come back, Judge. However, so there's some dispute here as to whether that's completely accurate, the initial stuff. That's why they were willing to amend it now. Nothing else.
Anything else? On the no ops, 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, 295 or 60 days. On the careless driving, 2.25. So you owe $420 then. And you still owe $327 on the no proof, including the clearance fee, and you still owe $285 on the left to center. So how are you gonna pay those? And when?
Is court able to waive impact late fees on those other ones, just to help them out a little bit as far as rising costs on ones?
And I wouldn't mind doing that if he had shown up. He didn't show up. That's my issue with it. He never showed up on this. You know, you gotta show a little bit of respect.
Again, Judge, I think it was just maybe a financial issue. He did ultimately, you did walk in on these, correct? He walked in on his own, Judge, on these, and he wants to take care of them.
Wasn't here in December on the leave the scene. We show caused him. He didn't walk in here until December or no, March the 16th, it looks like. Is that right or not? Does that sound right? Yeah, you didn't walk in until March the 16th or 17th. Did you hear what I said?
Yes.
So you didn't show up for 5 months. If you weren't working, there's no reason for you to have not shown up.
I didn't know I had warrants. I thought it was just financial.
They gave you tickets, right?
No, they did not.
The officer didn't give you the tickets? He filled them out, threw them in the garbage can or what?
I didn't get no tickets at the scene.
I'm not gonna waive anything here. I'm sorry. It looks to me like they were handed to him. Period. So he's gonna tell me when he can pay these. Is he just prohibited from working? I don't want to get into his medical condition too much. But he said he could do side jobs. If he can do side jobs, I don't know why he can't do other jobs. He hasn't worked in 2 years.
There's some days I can work, or some days I can't.
Just tell me when you can pay these.
Planning on 6 months,
6 months.
We're gonna be the.
When's the last time you went to the doctor?
about a year ago.
So you're just kind of sitting home hoping this heals on its own? You're not going to doctors? You haven't been there in a year and you haven't worked and you're doing side?
So I'm trying to get my stuff together to disability, the file for disability.
Get what I'm saying? I don't know. I don't know what your diagnosis is. I don't really want to sit here and talk about it. On the no ops charge, I'm going to give you, that's $295. I'll give you until June the 15th to pay that, okay? June 15th. You understand what I'm saying?
Yes, sir.
I'll give you until August 15th to pay the careless driving. If you don't have the money on those, you call the court, we'll go on Zoom. I'll give you an extension on the no proof of insurance. I'm going to give you until October the 15th. And on the left center, December 15th. Now, if you don't have the money, I don't have a problem. If you call the court, we'll go on Zoom, or you can walk in here and I'll give you an extension. But don't get into just thinking you're going to ignore me, because if you do, I'm going to send you to jail on you. You understand what I'm telling you? So I'm offering you the opportunity, if you don't have the money, to come in here at 8:30 on or before that due date, or to call the court and go on Zoom with me on or before the due date. I'll be glad to give you an extension. I don't care how many times we have to do it. But you just strike me as a guy that's going to ignore me, and that's not going to work well for you, okay?
Yes, sir.
You understand what I'm telling you?
Yes, sir.
All right, so I'm dismissing the show causes on those. I'm just setting up a payment plan. Heather, thank you. Purnell, Lamar, Fountain, 260-150-2398, B and C. Where's your client? Is he here, Mr. Zelnick?
Would you call Fountain? I got.
Fountain.
Oh, no, I got choked back here. Fountain's out. Sorry.
He doesn't talk about it.
I judge.
That's all right. Scott Anthony Chopek, 26I-7609, 1A, B, and C.
Fountain will be next, Judge. I just want to get the high profile cases out of the way.
I got it. I hope nobody was hurt in this, were they?
No, it's already been resolved with financial settlement.
Oh, it has?
Step over just a little bit.
Good morning, Mr. Chopek. Your name?
Judge.
How you doing? Good. How about you?
Good.
Your appearance?
Edward Zelenak for the defendant.
All right, so this is gonna be a responsible plea. You know, I know Mr. Chopek, of course, you know that, I'm sure.
Well, I knew, and I
Can I just,
worked this whole thing.
So is the Grosse Ile,
He's here and she agreed.
Ms. Cordes?
Yes, I was back there. That's what took me so long.
That's fine, that's not a problem. Call her in here real quick. So this can be a plea of responsibility to dog license, no dog license. What happened with this, the misdemeanor? They're dismissing it, but I
Yeah, the
mean,
dog's been disposed of. There's just some.
so your dog you put down? Yes?
Yes.
I'm sorry.
Thank you.
All right, Heather, I want to make sure I know the dog licensing charge and
She actually breaks through it, wherever you.
bring in whoever.
Yeah.
So first of all, does he stand mute, wait for a reading on the misdemeanor?
Yes, he does. And I thank you for your indulgence. Both days was just set for I was out of town.
Don't worry about it. It's fine. So he's going to plead to the civil infraction, no dog license. They're going to dismiss file C, which is the Animal Violation Vicious Act. And they're going to dismiss file B, which is the civil infraction of dog at large, right?
Yes.
And you said there was some kind of restitution. The dog, Mr. Chopek's dog was euthanized? And then what happened with any restitution?
Cash settlement with the individual who was the victim of the bite.
Yeah, another dog got dead and we covered the cost of the vet bills. And they had some other expenses for their vacation got interrupted because of the bite.
Okay, good enough. Come on up here, somebody for the township. Come on up, please. How you doing, sir?
I think we gotta put the detective on the road, Jay,
For what?
because
Come on up.
he's.
Your name?
Morning, Your Honor, Matt Wayne, on behalf of the Township of Grosse Ile.
So the defense dog was put down, euthanized, and I just want to make sure they're telling me that restitution was made, and then I presume the victim satisfied here? The owner of the dog?
You know, there's formally restitution, but there's financial compensation.
Well, I just want to make sure the victim is good with this.
But so I would have to confirm it again because there was financial compensation that was made. That's my understanding from Julie Cordes.
Where's she at?
She went back into the.
Call her up. Have her zoom in, will you please? Just have her call in.
Yes.
She can do it right now. She can pull over and I'll be happy. Just do that for me, will you please? Just bear with me, Mr. Chopek. I'll have you out of here in a minute, okay?
The file.
Okay. Joseph Edward Poor, 26B150417 and B and C. Your name, counsel?
Good morning, Your Honor. May it please the court, Ezra Goldman, P 48965 on behalf of Mr. Poor, who's sitting on my right.
All right. Your name, sir?
Joseph Poor.
Okay, I need you to get a little closer to the device. I didn't hear you very well there.
Joseph Poor.
All right, counsel. So he's charged with operating while intoxicated, resisting, obstructing an officer, and possession of a concealed weapon. Does he stand mute and waive formal reading on all of those?
Yes, for purposes of arraignment. Yes, sir, Your Honor.
All right, so now he's going to plead guilty to operating while impaired. The OWI will be dismissed, and the prosecutor is also going to move to dismiss the RNO as well as the possession of a concealed weapon. Is that true?
A deal too good to turn down. Yes,
Yeah.
it's true, Your Honor.
All right, and is that what you want to do, Mr. Poor?
Yes, sir.
I just can't hear you.
Yes, Your Honor.
All right, so if you plead to operating while impaired, the OWI will be dismissed. The concealed weapon charge will be dismissed. The resisting obstructing officer will be dismissed, and the possible penalties are up to 300 fines, 93 days jail, 360 hours community service court costs are all those 4 points. License suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that, sir?
Yes, Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. If you plead guilty, you're waiving your right to remain silent. You're waiving your right to a trial by court or jury. You're waiving your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. Do you understand that?
Yes, I do, Your Honor.
If you plead guilty, you're waiving all those rights. You're waiving your right to a trial. You're waiving the presumption of innocence, and you're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, I do.
To the charge operating while visibly impaired, how do you wish to plead?
Guilty.
Were you operating a motor vehicle in the township of Brownstown
Yes,
on
yes, sir.
February 21 of 26 at 11:11 PM on King near Marvin?
Yes, I was.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
I had about 3 beers at the bar. It was just regular beer.
What else did you have?
That was it. I might have had 4.
How
before I
big were,
left.
did you have any shots?
No,
How big were the beers?
12 ounce.
Was your ability to operate the motor vehicle impaired because of the alcohol consumption? And if so, in what way?
Yes, it was, sir.
Why were you pulled over by the police?
I'm not exactly sure. It was snowing out, so I may have been swerving a little bit.
You think you were swerving a little bit?
Probably. I was eating while I was driving, so.
Think you were
yes.
swerving a little bit, at least in part because of your alcohol consumption?
Yes.
Counsel, do you stipulate that the intoxilizer results of 0.120 was an accurate plea or accurate reading for purposes of the
Your Honor.
plea?
Yes, I do for purposes of the plea, and I want to suggest that if he had 3 or 4 beers, I think with his size, it's probably 0.12. Makes sense.
Are you on probation or parole right now, Mr. Poor?
I am not, sir.
Anybody force you to plead guilty?
No.
Plea is accepted. I find it to be an accurate plea to the charge operating while impaired. The drunk driving or OWI, R&O, and possession of a concealed weapon are all dismissed on motion of the prosecutor. $1,000 personal bond, no alcohol, controlled substances, or marijuana. No alcohol, illegal drugs, or marijuana. You're not to purchase, possess, or consume any one of those. We're going to have you screened and assessed, so I'm going to ask you, you live way out in Chelsea?
Yes, I do, sir.
Counsel, I'm going to have you call, write this down, please. You call our probation department, 734-671-0201, extension 245. That's 671-0201, extension 245. Tell him I told you to call. Find out when would be a good time for him to come over. Tell him I asked you to call there and that he's coming from Chelsea. Okay? And then we're going to give you a sentence date. What do you have for me, Heather?
We can do May 6th at 8:30.
May 6th at 8:30. Good with you?
Yeah, May 6th, 8:30 is okay. Is that in person or can we do that by
Okay,
Zoom?
as long as you're both in your office, I don't mind if you're there. You either both have to be here or both have to be there, okay?
Sounds good, Judge, and we'll call right away.
Okay, good enough. Thanks a lot. Have a good day. And you have to submit to that screening, sir, and we'll see you here May 6th with your lawyer on Zoom or in person, whatever you guys want, okay?
Thanks very much, Judge.
Good morning once again, everybody. It's TCF Live on a Wednesday, just about to enter our third and final hour for the day. Let's stay in Michigan, but let's go over into Ingham County and say good morning to Judge Aquilina. I like doing that.
Your appearance?
This is the public defender Joseph Hardy on behalf of Mr. Carter, who is standing here to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Sir, you pled guilty to count 1, failure to file income tax with intent to defraud, punishable by 5 years, and count 2, failure to file income tax with intent to defraud, punishable by 5 years. Do you recall that?
Yes.
And I have a probation violation that's alleged. And it reads, on or about October 28th, 2025, defendant opened or took ownership of a business where he handles other people's money. Is that the extent of violation, Ms. Gale?
Yes, Your Honor.
All right, counsel, is that what you and your client have discussed?
Yes.
All right, and are you waiving further arraignment?
Yes.
Will this be a plea or a hearing?
At this point, we would like to set for a hearing just because the AG is not here, so. We would like
I don't
to-
care. What do you want to do about that? What's going to make the difference with the AG?
Well, we'd like to just, as discuss their attempted approach.
Discuss what?
Discuss what their approach is going to be, but.
Well, right now it's nothing. I think they're letting probation handle it. that they had an opportunity to be here and they're not here. I mean, let me ask you this, do you want a hearing or is he gonna plead? I mean, because here's the thing, have you talked to probation?
Yes.
Okay, and you're not happy with whatever they're recommending?
Well, I believe after speaking with Miss Gale, that they were, that they believe that the recommendation was going to be jail time with an extension on probation. However, there was concern that he would not be able to pay restitution if these recommendations were indeed followed. After speaking with my client, you know, it's his contention that he did not open a new business. So at this time, we would like to set for a hearing.
Did you open a new, let me say, on behalf of the people, our probation, what kind of business is this?
He opened a oil change business titled Executive Car Wash and Oil Change LLC.
Okay, and you have evidence of that?
Yes, Your Honor.
And he's not just working there, he owns it and is handling other people's money?
Yes, Your Honor.
Is he paying restitution?
He has paid $15,650 and he owes $19,262 left.
So we need to go halfway.
Yes, Your Honor.
Is there any evidence of defrauding someone else in this business?
Yes, Your Honor, there was concerns. The reason it was brought to my attention, not only did we not know that he had the new business, but someone contacted us saying he owed $5,000 in bulk oil to an oil company called Leiden Oil.
All right, we're gonna set this for hearing. How much time do you need to get them and work with the Attorney General? How much time do you need to prepare? And you all need to talk about this because I don't want to have another hearing date, another docket time, and we're not prepared to go. Everybody should have been prepared to go today. How much time do you both need?
I will defer to probation.
Whatever you desire. I don't honestly, I don't know if anyone for the oil company will come to testify. So if I can reach out to them. When I talked to them today, they said they did not have a police report as they chose not to file one because they did not want to publicly damage their image. So
Okay, well, that's stupid, but okay. I don't understand that rationale. I never understand that rationale, but there must be a bill that says unpaid, right?
I can update my ear.
So you have some evidence and you have some evidence it's paid? Probably by the time of hearing it will be paid, huh?
That is my hope. However long the court is willing to give, because my client is in the current state of making payments. We want to give him a chance to possibly bring any type of alleged arrearages up to date.
Off the record moment. Need that contested evidence return. I agree. Thank you. Off at 1:30.
Thank you, Your Honor.
Thank you, Your Honor.
Probation will continue, sir. Figure it out.
I have, and we'll thank you, Your Honor. Yes.
Don't say anything else, just figure it out. And
Thank
please contact the Attorney General.
Yes, sir.
And you all have a chat. Thank you.
Thank you, Your Honor.
1:30 at 1:30, May 12th at 1:30.
Yes.
Yes.
We're good to go on Georgia.
All right, we'll probably come back after she racks up another contestant, but let's go back to Judge West for now.
Mitchell's case is set for trial to begin with jury selection next Monday in cause number 24 DCCR 0170. I've gotten some information that Mr. Burbank, you're set apparently in, Orange County on a murder case. Judge Arking.
That, I will tell you, that case had troubles in witnesses for about an hour. So what actually said, I
Okay.
don't know whatever, but the caller.
No, I mean, it sounds like we've already received some information that it was specially said with witnesses being flown in. Is there any anticipation that that's could potentially get worked out? I know things change at the last minute, but
Last communication I had, I'll tell you with the court, I thought last week, Thursday afternoon, Friday. So I'm like, well.
and he's in custody.
He's-
So do y'all have a pretrial set this week or just getting started next week?
We there was no.
Okay, Ms. French, obviously, I know the cases that have to do with children do take precedence, at least in my court, if I have to number them, but I don't know that I can get him if there's somebody in custody with the case. I think it's about as old or the same approximate age as this one. So what I'm going to do is just maybe hold it, just double check that there isn't anything that's going to cause that to be reset with witnesses. Because if it is, then this is definitely going to be numbered. Is the state ready if we go?
The state is ready. I would just say that with the caveat that I have a tendency to not want to re-traumatize by making children talk about these things too early. And so if I could just have a little leeway, if at the last minute, this is the case that goes. Because I don't want to have to bring her in unless I know we're going to trial.
Well, you're not always going to know, unfortunately. And so I would think in this one, we're already on Wednesday. It's different than most weeks. I'll see what I can do to double check that the court's not going to have any issues over there. And number the cases today at the end of the docket. So I'll let you know at the end of the day.
Thank you.
State's otherwise ready, Your Honor.
All right, thank you. Jalen, Eli, Mr. Burbank, Mr. Coleman.
Jalen, Eli.
You have docket at 1:30 today.
Mhm. We're doing jail this afternoon. One, I'm sorry. Thank you.
Say something. Come on. Mr. Burbank. I know. We could get rid of this. I got rid of one over there, murder case over there, but give me a hand. Put something out, Jim.
Good morning, sir. Are you Jalen Eli?
Yes.
And this is 25 DCCR 1004. Mr. Eli is charged with forgery of a financial instrument. And Mr. Burbank, what is the announcement?
Your Honor, I'm going to be candid with the court. I dropped the ball on this one. There are some banks from Minnesota. And to be honest with you, when I looked at it yesterday afternoon, and I was like, oh.
More than you expected. And it looks like you, this isn't very old. You were hired, looks like in February.
Talked about it this morning, Judge, and I'm not opposed to a reset.
So I'll just do a normal reset, give you some time to kind of get through that.
And then, of course, I have to talk to him about money to maybe resolve it.
So Mr. Eli, make sure you stay in touch with Mr. Burbank, make an appointment visit with him before that next court date, once he goes through everything, and that way we'll be able to get an announcement, okay?
Yes.
All right, thank you.
Your Honor. It's hard.
Thank you, Mr. Burbank.
Thank you, Your Honor. I'll see you soon.
Mr. Morian, you've got Carolyn Whitaker, Ms. French. Oh, Mr. Burbank, hold on. We added one on.
Oh, yes. I'll be here, Judge, when you have.
All right, I'll take care of that in just a minute. Thank you. Good morning, ma'am. You're Carolyn Whitaker. Morning, Mr. Moran.
Good morning.
And Ms. Whitaker's cases are set for trial to begin with jury selection next week. And what is the announcement?
State is ready, Your Honor.
Defense is ready, Your Honor. There's just a few preliminary things I would like to take up with the state, with the court. There's just a couple of motions that I filed, my standard motions, such as my, motion disclosure rule 702 witnesses and things like that. I've sent those. I believe I filed those over a year ago. Those are just the preliminary things I would like to address. And I don't believe there's any issue, but other than that, I mean, we're ready.
Okay, so what I'll do, I've got jail docket this afternoon. And as soon as I'm finished with that, I will number the cases. If this turns out to be the number one case, then we can set a time to take care of those before jury selection.
Thank you.
And if you'll just go through all of those, make sure if there's anything that hasn't been taken care of, just because I know you got on the case after probably those were filed. So
I will say that I did work with your assistant last week.
Yes.
On Friday.
Yes.
To go through all of the discovery.
Yes.
And make certain that you have everything that
Yes.
we have.
And Judge, we bait stamp all of our discoveries, send it to the state to make sure that everything I had, I sent over that my bait stamps on it. I believe we've corresponded. I think we did, or we sent a list of everything we had, or maybe it was different, but I know that we've corresponded between the state,
Okay.
everybody, what
You have
what
everything.
y'all have.
okay.
And just for the record, these motions I filed are my standard pretrial stuff, nothing crazy, no suppressions or anything at this point.
If there's anything that you think is kind of a standout that Ms. French needs to look at, let her know that. Otherwise, if it's number one, we'll take care of it at the appropriate time. Any other negotiations with regard to any agreements or anything like that?
Your Honor, we've not, been off for a while, after Mr. Hoffpower was on the case, that offer was perfected. I've got my week blocked off for next week.
Okay. All right, then it will be numbered. Again, it'll be the end of the day today, probably first thing tomorrow morning, potentially, because we're doing everything today. I'll number the cases. But based on the one that I thought was going to be number one, this one just kind of moved up the list. So I'll let you know.
And is it just, I know I'm not holding you to it, just from planning purposes, is it looking like this one's gonna be set number one? And and if you don't know, I'm not trying to press anybody, I just.
I might just ask
It's-
you, is there anything here that you think you don't have, or are you just looking for a ruling on your motion?
Just ruling on motions, just like have things done.
You know, there's one that I have in a murder case that's in custody.
Okay.
That we'll know about this afternoon, that's about the same age as this one. And so if that one for some reason is ready, it might go ahead, but you'll know by the end, late this evening.
Thank you.
Okay?
I appreciate it.
Thank you.
And Your Honor, who do I need to talk to about getting copies of their lists and everything like that?
If you'll get with Ms. Holmes.
Thank you.
Yeah.
Thank y'all so much.
Yes, sir.
May we be excused?
Yes, thank you.
So much.
All right, see y'all next week. Says Mr. Paget.
All right, let's go back to Judge Aquilina.
This is docket 256463FH, People of the State of Michigan versus Gregory Leroy Jordan. Counsel, your appearance for the record.
Good morning, Your Honor. APA Revokes on behalf of People of the State of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, on behalf of Gregory Jordan, standing to my right today.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand the court or your attorney?
No.
Is there medication you're supposed to be on, you're not on?
No.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had an opportunity to review the pre-sentence investigation report and talk to your attorney?
Yes.
All right, on behalf of the people, any corrections, additions, deletions?
Not to the body, Your Honor.
Judge, the defense has one to the body.
Okay,
His education level is the 11th grade as opposed to the 12th grade.
That's on the cover page and also probably inside.
Yeah. The education section on page 10 of the report.
Changes been made. And it does say under the narrative 11th grade, so now it's all consistent.
I had no other changes to the report.
Your Honor, in regards to that change on the basic information report, it also says highest grade completed, and I think that should be changed to the one.
Yes, thank you. Changes been made. And what about the guidelines?
Yes, Your Honor, in regard to the guidelines, OV 12 is currently scored at 0 points. However, Your Honor, OV 12 should, or yes, OV 12 is scored at 0. It should be scored at 10. OV 12 is contemporaneous felonious criminal acts. And Your Honor, there were 3 charges that were dismissed as a result of this plea, meaning that OV 12 should be scored at 10 points.
Any objection?
No, Your Honor, I think that's correct.
It is 10, that means the total will be is 20, is that still level 2?
That is, Your Honor.
Yes, Your Honor.
Thank you, and I'm changing the basic information sheet to reflect the 20. On behalf of the people.
Yes, Your Honor. I believe that the recommendation from probation should be followed in this matter. The people, I will say, are a little concerned reading the report that the defendant, despite stating that he has an issue with substance abuse, does not believe he would benefit from substance abuse treatment. I'm also concerned, Your Honor, that based off this crime being a case where the defendant thought he was making sexual contact with a 14-year-old, he does not believe he would benefit from sex offender treatment. So both of those very concerning, Your Honor. However, I do believe that the recommendation for probation would be appropriate, Your Honor. So I'd ask that you follow the recommendation of a sentence of 48 months to 240 with credit for 182 days. Thank you, Your Honor.
Thank you. Counsel?
Yes, Your Honor. The defense as well would ask for the recommendation to be followed as in line with the Gilmore agreement agreed to between the people and Mr. Jordan, Your Honor. He made a poor decision. He recognizes that, Your Honor. He also recognizes he makes poor decisions when he's under the influence of illicit substances, Your Honor. We'll leave it to him whether he wishes to benefit from. Yeah, I'll leave that to him. I do want to note one thing: his parents, his mom and sister are here in the courtroom, Your Honor. They are supportive of him, but they also are unhappy with the choices that he made. The one thing I want to point out, Your Honor, is that there's a phone in custody of the Michigan State Police. I believe that phone was used in evidence, but I believe that phone also is on a family plan. I think the mother wishes to get that phone back so she could turn that into Verizon. I understand this case is over, but the people want to have to hold that phone for the retention period in case there's an appeal. I would ask that if we can get that phone over to the family doesn't have to pay a phone bill for no reason.
Sir, anything you want me to know?
I just heard that the prosecutor said that it was a 14-year-old involved. It's not what's true. Say on my report, it said 15-year-old.
Well, sir, under 16.
You understand? I'll just point out that she said that.
Okay. 14, 15, under 16, can't consent, is a minor, and you knew it, and I believe that's what you played to, correct?
Yes.
Okay, so police report may not have it right, I don't know, it's really a little effect and doesn't change the outcome here. So I appreciate you telling me. Anything else you want me to know? I'm sorry.
I have nothing else to say.
Sir, you obviously have a family who cares about you. When you were in front of me, you told me you were homeless.
Because I've been away from the family. I left home. And running around homeless for real, I don't have to be. I don't.
So you didn't like the mom's rules?
I mean, 38 years old. I didn't want to be under the house where.
So you prefer homelessness to following family rules, helping out? Is that what you're telling me?
No, not really. I just. No,
Well, let me ask you this.
I got under the influence of the drug influence and I didn't want to be in front of their face with that.
Well, I appreciate that. So what was so bad that you had to shove it down with drugs? Do you know?
The situations, like relationship situations with my baby mothers and kids and stuff like that.
So
I left.
illegal drugs don't bring you together. They
No.
drive you apart. You can't be with your children. You're not a fit parent if you're using drugs. Do you understand
I do
that?
understand that.
So it didn't help the situation, did it?
It did, made everything worse.
All right, sir. You are remanded to the Michigan Department of Corrections for 48 months to 240 months with credit for 182 days. You'll pay a crime victim's amount of $130 and $68 state costs. That's $198 that you'll owe, but that won't be due until a year after you're released. While you're in custody, whether you like it or not, you're under their control. You're gonna get out of bed and do the things you should have been doing. To include substance abuse treatment, attending AA and ACA, individual and group therapy, whatever they have to offer, you will participate in. You will go through trauma treatment if they have that, so you can get at the underlying issues that you have as a result of your relationships or lack of relationships, and figure out how to handle it other than shoving it down with drugs. You will participate in cognitive behavioral treatment, so you learn to make better decisions. You will also participate in sex offender treatment. You will have to comply with SORA, the Sex Offender Registration Act, as part of the statute, and comply with that once you're released. And before you are released, they will go over the requirements of that. You will complete your GED and trade school while you are in there as well. Is there anything I have missed aside from the rights?
Yeah, Your Honor.
I think you covered everything.
Sir, you have 42 days to appeal and request appellate counsel. As to the return of the phone can be returned to his mother. What is your mother's name?
Tanya, Tionia, Brewer Jordan.
Same last name as you?
Yes.
And that will be after the retention period, and law enforcement will, of course, need to wipe clean any child porn or whatever's on there that is illegal. And so she'll have to deal with the arresting agency because they do keep that evidence, and I'm sure they have dumped it. Probably it's not on the phone at this point, but I don't know their policies, so we have to be compliant with that. All right. Sir, do you acknowledge receiving your appellate rights?
Yes, ma'am.
Good luck to you, sir. It's your life. You decide if you want to be a free man or one who remains the rest of his life in prison. Get on the right road before it's too late, sir. Good luck to you. That's all.
All right, friends, let's head back down to Judge West.
You know. And sir, are you Michael Harrison?
Yes, ma'am.
And this is 25 DCCR 1859. Mr. Harrison is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, we've received everything but the videotape, and I expected it. I just unfortunately requested a little bit later than the regular discovery. I've also received an offer from Ms. Molfino I assure you that as soon as I receive the video, we'll make tracks. I have
Okay.
good communication.
All right.
with my client.
Any issue? And Mr. Harrison, do you have the auto ignition interlock device on your vehicle? All right, make sure you keep that on and don't drive any other vehicle that doesn't have it, okay?
Yes, ma'am.
And I'll just do a normal reset, stay in touch with Mr. Paget. Once he gets that video, you can go over that with him and we'll get an announcement.
Okay.
All right, free to go.
Thank you, Your Honor.
Thank you, sir.
May I have an excuse?
Yes, sir.
Okay.
Okay.
Save yourself.
Mr. Parker, you've got Brian Belvin.
I'm just gonna make a note in my file, if you don't mind.
He's outside.
You have me to email?
Just a next- It's right here and I'll write them down. Send it
I
out.
don't know why that we have a.
I don't know why he's on.
He's on JCDI. He's in JC. Thank you.
JCDI. Who's told him to go to JCDI?
Is it JCDI? Yeah, JCDI.
He's on pretrial, JCDI, as a diversionary. That makes.
If you complete the program, the case is dismissed.
Will be dismissed.
So he's on pretrial diversion.
Yes,
Right.
it's just the drug track
Okay.
of that, sorry.
That's okay.
But according to some changes, there are not dismissals at the time of entering
Correct.
into said contract any longer.
Okay.
And so with the lengthy reset, Judge, I'd have no reason to believe he's not doing great.
Okay.
And we.
He's in compliance and he's passed all the tests.
Lengthy 90
90
days.
days would be fine.
Okay.
You have-
Good morning, sir. You're Brian Belvin?
It's a year program
Right.
and I'm only a month in.
All right. So what we'll do is, just so that I can keep track of how things are going, I'm gonna set it out about 3 months or so. We'll just kind of check back in, make sure everything's still going well, and then we'll do the same, maybe even a little longer that second time. Okay? So keep doing what you're doing. Sounds like everything's going well. Yes, sir.
And I have one other one, Judge.
Yeah, Christopher Rhodes.
He's in the hallway. It's, Christopher?
Charles
yeah,
Christopher Rhodes, sorry. Good morning, sir. You're Charles Rhodes?
Yes, ma'am.
And this is 26 DCCR 0209. Mr. Rhodes is charged with driving while intoxicated with a child passenger. And what is the announcement?
All right, I think we about have something worked out. I need to provide some documents to Ms. Malpino, and I think we'll have it worked out next time.
Okay. Any issues? All right, Mr. Rhodes, I'm going to reset your case, just a normal reset. Make sure you stay in touch with Mr. Parker and he'll let you know what's going on before that next court date and we'll get an announcement.
Yeah,
then.
thank you.
You're free to go.
See you this afternoon, Judge.
Thank you, sir. Is there a Mr. Charles Neesmith?
Yes, Your Honor.
Good morning, sir.
I'm sorry, I was gonna press something, Your Honor, if I may approach.
Yeah.
Thank you. Your Honor, for Deshaun Robertson this morning, she be patient, just sitting outside right there. I'm here for two things, Your Honor. One is, good morning. In the case,
Hold on just a second. Let's get Deshaun Robertson, please. Deshaun Robertson. Good morning, ma'am.
Morning.
You're Deshaun Robertson?
Yes, ma'am.
All right, go ahead, sir. I'm sorry.
Yes, Your Honor. If it please court, I'm here this morning on behalf of Ms. Robertson. There's a couple of things and evidence that I'm requesting. It's criminal history of the alleged victim, Mr. Sanders, as well as requesting time from the court for two things. One, I filed an ex parte for an investigator this morning, not just for criminal history, but for any exculpatory mitigating evidence in this case, because there may be an issue of self-defense. And that ties into Cienter, which would be at a trial if necessary for Ms. Robertson, because she's been MHMR all her life,
Okay.
going towards intent for an assault, Your Honor.
I can get him criminal history. The complaint actually was just looking at it when you walked in.
It's
All right,
extensive.
so I'll do a normal reset and I'll take a look at that motion and let you know what my ruling is on that. Ms. Robertson, make sure you stay in touch with Mr. Neesmith. He'll let you know when you need to be back and he'll visit with you about anything that he's learned between now and the next court date, okay?
Yes, you.
All right, thank you.
It probably is still pending because I thought.
Yeah, it'll take a day, maybe this afternoon. I'll take a look at it as soon as it comes through.
I had to fix a Canon printer late last night. so-
Uh-oh, all right, thank you. Y'all are free to go.
Thank you, Your Honor.
Okay, second.
Yeah. See, Mr. Rojas, you have Brandell Griffin on sentencing.
One that can make me inside.
Okay.
Emailed you the motion yesterday, read motion, I haven't checked my email this morning. I just want to make sure the court movement is agreed. I mean, ordinarily. Yeah.
No response, Your Honor?
So a couple things. This is 24 DCCR 1666 and Mr. Griffin was here in court and entered a plea of guilty to a lesser included offense for a 30-day sentence, gave him some time for sentencing to come back today. So the first thing I'm going to do is forfeit his bond for non-appearance and reset it at $100,000. I am also going to reject that plea offer, or that plea agreement. We'll delete all of that paperwork and see, I guess, what happens once we get a hold of Mr. Griffin. If for some reason you get a hold of him this morning and get him here, if there's some, legitimate excuse, just let me know. We'll take care of it.
Yes, ma'am.
All right.
I'll make a few phone calls right now.
Okay, thank you.
You just.
See that. Mr. Vasquez, I don't see that you have anything this morning.
Well, I did, Your Honor. I thought I had Mr. Williams. That's the sound.
This is at 1 o'clock. This morning, we're doing bond docket, this afternoon, jail docket. We'll be here all day. See you at 1.
Thank you for doing my thinking for me.
That's okay. Let's see. See Mr. Chandler.
When I do it, but yeah, it'll be in the case.
Mr. Broussard.
Just.
Okay, I'll take care of it in just a minute. So again, you're Darian Broussard. And so, Mr. Broussard, you're here in my court in cause number 25, DCCR 1441, and charged with, hold on a second. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And I've given you some time to try to hire a lawyer. Well, hang on, that's not even what my biggest concern is at this point. Because you're already on misdemeanor probation. And for some reason, you've been testing positive for THC since last October while you were on that probation. And they let me know that, but I don't know why they haven't filed a motion or done anything about that. So
I paid it off, and that's what the judge almost told me to pay it off, because he was like, I don't know why you're still going to probation.
you're still going to probation because you're still using marijuana while you're on probation and while you have a felony court case pending, right? So I don't know what makes you think that that's okay, because it's not. And the fact that you were on probation and doing that, and now you're still doing it.
I wasn't still doing it. I was telling my probation, I was smoking wax or resin, pure THC, and I was telling him that I was doing it 30 days. It was kind of hard to come out of my system still. And I told him I needed another 30 days. He said, all right, come back May the 7th. Because he was like, it was going out the system, but I don't know.
But you've been doing it the whole time, right?
Yeah, I was doing it all the time. Then when I got out, I stopped. And it was still in. I got out, I went to jail.
You got out. What'd you go to jail for? This?
Yes, and I got out like 3 days after that.
So you're telling me you haven't used since you've been to jail in this
Yeah.
case?
And the only reason it's still in my system because I smoke wax in the bone, like liquid THC. And I
Okay,
explained that to my probation officer, explained it to the superintendent. She was like, it probably take 120 days or so because it's pure THC.
he's been out since September. You've been out of jail since September?
No, yeah. So no, I went to jail since I went out of jail since November.
It's April. Yeah, okay, so I'm gonna find that you have violated the conditions of your bond.
I didn't violate it.
There's no way it's still in your system if
I'll-
stop talking because you're gonna make it worse,
Yes.
okay? There's no way. I don't care what you're smoking out of whatever you're smoking it out of, hang on. Because if the last time you did that was in September of last
No,
year
so-
or November of,
No, it was January. That was my last time because I was like,
so you're not, see,
I'm sorry.
you're not telling me the truth.
yes, ma'am. I'm saying my last time when I got out of jail was in November. That was the first day I got out November the 1st.
Mm-hmm.
I didn't go report till I think September. Yeah, September. And I pitched 30. And then I pitched 30 3 more times after that. And I told him I was like, sir, I was smoking hardcore THC. I didn't smoke
None of
bud.
none of that would make you test positive today.
I tested positive again.
Why do you think we're having this conversation? Yes, you tested positive.
Keep testing positive.
Well, because you're keep using. Come on now. Here's what we're gonna do. I'm gonna make sure that you're not using at least for some amount of time.
I'm not using Miss West.
I'm going to raise your bond for violating your bond conditions. The fact that you've been using while you're on probation and they let you keep going makes no sense to me. Hold on, makes no sense to me at all. I'm going to raise your bond in your case for violating the condition of your bond. Hold on a second. To $50,000. Condition of that bond, if you make it, is that you will be required to have a drug patch on at all times.
Told him that from the first time. I told him that I said,
Listen.
a patch. I'm serious, Miss West.
Okay, well, now you're gonna get one. But if a drug patch is what's gonna make you stop using, that doesn't make any sense either.
I've been stopped. That's what I'm saying.
Okay, I don't believe you, so I'm gonna make sure of
That's
that,
understandable.
because it doesn't make sense what you're telling me on the dates. So again, you have to have a drug patch on within 24 hours of your release if you make that bond.
I'm not.
And so if you don't make the bond,
Okay.
you're going to get a court-appointed attorney. I will consider at some point, and we'll let that attorney know, reducing your bond back down after I know you have sat for some amount of time and not used. All right? You can go back with the bailiff. If you'll make a note, because I believe he's gonna get that. Just that I would consider after he sits for a minute, reducing the bond back down. Oh, Charlie, Mr. Rojas, that's yours. The one that I was just talking to. So if he doesn't make bond, if you'll visit with him and by that next court date, I would consider just bring it back to my attention, reducing the bond back down with the patch, but we're gonna get you clean. Yeah.
Okie dokie, friends, let's try something new. We're going to stay in Texas, but this is Judge Alex Kim in the 323rd District Court, Tarrant County, Texas.
Okay. Let's start this then. Court calls number 323-124614-24, styled on the matter of Samuel Lee Blackmore. We are here for a hearing under 54.11 of the Texas Family Code on a parole transfer hearing. Mr. Blackmore, just so you understand, that this is a hearing to make a determination on whether I should transfer you to the institutional division of the Texas Department of Criminal Justice, or if I should release you into the community for, with approval for release under supervision. This is a hearing that I told you about the last time we saw each other. You do have certain rights at this hearing. You have the right to remain silent. You have the right to an attorney. You have the right to cross-examine and confront adverse witnesses. You have the right to present evidence and argument. You do not have a right to a jury, and you have the right to examine any report that is being used through your attorney, Mr. Newman. Because there is no agreement, you do have a right to appeal my decision. Mr. Blackmore, this is a hearing where the law allows me to make a determination because you are a determinate sentence offender on whether you should be released into the community or transferred to TDC. There are factors I must consider that the law requires me to consider. I must consider the experiences and character of you before and after commitment to the Texas Juvenile Justice Department. I must consider the nature of the penal offense that you were found to have committed and the manner in which it was committed. I must consider the abilities of you to contribute to society. I must consider the protection of the victim of the offense and any member of the victim's family. I must consider the recommendations of the Texas Juvenile Justice Department, the County Juvenile Board, local juvenile probation department, and prosecuting attorney. I must consider the best interest of the person. And finally, I must consider any other factor relevant to the issue to be decided. After considering these factors, I must decide whether you should be released under supervision or transferred to TDC. I can order you held in the county jail waiting for your pickup by TJJD or TDC. I can also order your return to TJJD with or without approval for release under supervision. The court at this time will take judicial notice of the court's file and all of its contents. Specifically, on January 30th of 2025, this court found the child delinquent for the felony offense of aggravated robbery, and also found the child delinquent for the felony offense of aggravated assault with a deadly weapon. At a separate and distinct hearing, this court found a need for disposition and committed the child to the Texas Juvenile Justice Department for a period of 8 years. Remember, Mr. Blackmore, at that time, I told you that we would see each other again for me to make a decision whether I should transfer you or to parole you, and that I would consider everything that you've done between that date and the date we saw each other again. I originally told you I would see you shortly before your 19th birthday. As the case may be, there's a request for early transfer from TJJD. That is why we're seeing each other before I expected to. All right, so Ms. Terrio, your first witness.
State would call Tammy Coy.
Hey, Ms. Coy. All right, please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, thank you. Ms. Terrio, please proceed.
Ms. Coy, can you state and spell your name for the record?
My name is Tammy Coy, Tamicoy.
And how are you currently employed?
I work for the Texas Juvenile Justice Department.
And what is your role with the Texas Juvenile Justice Department?
I oversee the Sentence Defender Department, and we process sentence defender youth out to either TJJD parole, TDCJ parole, return to court for required hearings at 19, and return to court for early transfer hearings like today.
And I guess, and as was mentioned earlier, we're here in court today because you're requesting Texas Juvenile Justice Department is requesting an early transfer of Samuel Blackmore.
Yes.
Okay. And do you see Samuel Blackmore in the court via Zoom today?
Yes.
Okay. And can you identify him by an article of clothing he's wearing?
He's wearing a green jumpsuit.
Your Honor, may the record reflect that the witness has identified the respondent?
So reflect.
And in preparation today, did you, was a master file containing all of the respondent's records along with the request for transfer created?
Yes.
And was that provided to all parties, including the state, the court, and the defense attorney?
Yes.
Your Honor, at this time, the state and respondent have agreed to stipulate to the admission of Petitioner's Exhibit 1 for all purposes, 1A for record purposes, which contains the master file.
We so stipulate. All right, then petitioners 1 is admitted for all purposes and 1A is admitted for record keeping purposes only.
So Ms. Coy, I want to talk a little bit about why we're here for the early transfer, okay? When is the respondent's sentence set to expire?
October 9th of 2032.
Okay. And when would his minimum period of confinement be? Like when would what is that date?
October 9th of 2027.
And how old would he be on that date?
He would be 18 and a half approximately.
Okay. And if this case was to proceed as normal, when would his transfer release hearing be?
Actually, if it were to proceed as normal, he wouldn't require one because he can complete his minimum period of confinement before turning 19. So TJJD would have paroling authority over him.
If TJJD chose not to parole him and to keep him past his minimum period of confinement, when would the hearing be scheduled for?
One would have to be scheduled. We'd either release him at 19 to adult parole, or one would have to be scheduled prior to 19 for another early transfer.
Okay. And how old is the respondent currently?
He is 17 years, 1 month.
Okay. And why is Texas Juvenile Justice Department requesting early transfer?
While Samuel has been with us, he has had multiple incidents, behavioral issues, and aggressive behavior.
Okay. Is there a criteria that is in place for someone to qualify for early transfer?
Yes.
Okay. And what is that criteria?
They have to be at least 16 years old. They have to have been with us at least 6 months. And if they commit a new felony or Class A misdemeanor, that would could make them eligible. 3 or more major rule violations confirmed through a level 2 hearing would also meet eligibility, and an unwillingness to progress in treatment.
Okay. And obviously Mr. Blackmore met the criteria in this case, correct?
Yes.
Okay. Was he made aware that he was in danger of being transferred early?
Yes.
And what was his response to that?
His response at some points has been he wants to go to TDC and does not want to work the programming.
Okay. Did you see any improvement in his, like massive improvement in his behavior when he knew that he was in danger of being transferred?
So yes, we saw an improvement. We initially started his packet in the end of July. And at that point, he had already met the full criteria by having 5 major rule violations confirmed at that time. After that, his behavior did improve, at which point the packet was placed on a 60-day set-off to give Samuel time to continue working, to continue to see if he would maintain that positive progress. Although during that time he did initially, but then he reverted back to his aggressive behaviors.
Since his commitment, how many incidents reports has he incurred?
95.
All right. And how many admissions to the regulation and safety unit?
11.
And how many level 2 hearings has he had?
He's had 5 level 2 hearings confirming 8 major rule violations.
Okay. Can you briefly list those infractions and the dates?
Yes. March 4th of 2026, fighting bodily injury. March 27th, 2026, fighting no bodily injury. December 31st, 2025, exposure. June 26th, 2025, assault of staff bodily injury, assault of staff no injury, possession, use of a prohibited substance, white powder, and May 28th, 2025, tampering with safety equipment and fighting no injury.
What interventions were given to Mr. Blackmore to assist him in trying to complete the Texas Juvenile Justice Department programming?
He has been placed on egregious behavior protocol approximately, I believe, 7 times, and repair an additional 5 times, which both programs help the youth to work specifically on the behaviors that they're exhibiting and better ways to handle their problems, as well as having the 60-day set off where he was noted that we would be pausing that decision to move forward, and then attending regular general programming.
And were any of these interventions effective?
Only for a short amount of time. They do tend to, he can pull it together and respond well, but then eventually reverts back to his old offense patterns.
Were there any specialized treatments that were recommended for Mr. Blackmore?
Yes, he was recommended for power source and substance use services. He has not been in either program to date. However, we're no longer using power source, and he is receiving individualized DBT to address the violent offender programming need.
What's DBT?
Dialectical behavioral therapy.
Okay. So is there a reason that he was never enrolled or started the 2 programs that you just mentioned?
Likely it's probably a combination. His behavior was not stable, as well as his minimum period of confinement not being up for well over another 1.5 years now.
Okay. So I also read, was he referred to the violent offender program?
Yes.
Okay. Has he had an opportunity to participate in that program at all?
No, that would be power source, which we're no longer doing.
Okay. So if you're no longer doing that, do you have an alternative program instead?
Yes, he's getting the individual DBT, which is specific and above and beyond. So normally youth meet with case managers and do their DBT groups twice a week. Additionally, now they're meeting with an mental health professional and having individualized DBT with them as well.
And how is that working out?
Again, kind of like his behavior, up and down. Some days he works, some days he refuses to go to group. Some days he has his assignments, some days he's lost his diary cards. It just really kind of depends on where he's at that time.
Okay. And what is Mr. Blackmore's current stage?
He is a stage 3.
Okay. And that's about middle of the pack, right?
Correct.
Okay. So with him being a stage 3, and when did he get his last promotion?
April 1st.
So, would you agree with me that that shows improvement?
Yes, it did show some improvement.
Okay. So with him reaching a level 4, I'm sorry, a level 3, why is TJJD still recommending his early transfer to the Texas Department of Corrections?
It's his overall behavior while he's been with us. His last fight occurred approximately 1.5 months ago, when he knew he was still under review. And he tends to do well for short times and then reverts back to his aggressive behaviors.
Okay. How is his behavior affecting or having an impact on the other youths that are at the facility?
Yes, it can.
Okay. And you mentioned he keeps reverting back. Is that the primary, or I guess I should ask, what is the overall primary concern when you have this that TJGD has when it comes to the respondent's behavior?
Really that he more often than not will choose not to follow programming, not to use the skills that he's been taught and is learning, and continues to revert back to his aggressive behaviors to handle problems rather than using skills that are taught that would keep from that happening.
Okay. And then one last time, what are you requesting of the court today?
The agency is requesting he be transferred to the the Correctional Institution Division of TDCJ.
Pass the witness, Your Honor.
Newman, cross-examination.
Thank you, Judge. Good morning, Ms. Coy.
Morning.
All right. I want to talk to you about a statement you said a second ago first. I think it might be a bit hyperbolic. You said more often than not, he's not complying.
Yes.
He has 95 incident reports, and he's been there longer than 190 days. Is that fair?
Yes.
All right. I just want to clarify that. Now, I want to talk to you about the stage system that you use. There's a 5-stage system. Is that accurate?
Yes.
All right. There's 4 numbered stages, and there's one that has a word as its stage. Is that fair?
Correct.
All right. And so when you say somebody's in the middle of the pack in stage 3, we're talking about somebody who's engaged in their academic and behavioral program. Is that fair?
Yes.
Additionally, they're otherwise complying in the dorm.
Yes.
All right. And so when we talk about those 95 incident reports, as of August of last year, we had 75.
I would have to, I'm don't know the exact.
All right. Do you think it might refresh your recollection if you reread the master file?
Oh, are you referring to the psychological?
Yeah, I was going to direct you to Bates stamp number 9.
Yes.
So is it fair to say over the last 7 months, there's been 20 incident reports?
Yes.
All right. And so when we talk about somebody making this type of progress, part of what TJJD does is cognitive behavioral therapy, but all rolled into rehabilitation.
Correct.
That's ultimately the charge of TJJD is rehabilitation.
Yes.
All right. I want to talk to you about the availability of those programs. Specifically the Power Source program. Before it was done away with, was Mr. Blackmore ever number 1 on the list to go for the waiting list?
No.
All right. Was he ever number 1 on the list for the sus treatment?
No.
All right. And so a big factor was the waiting period and why he wasn't able to engage in that.
Yes.
And the purpose of these programs was to address his criminogenic needs and to provide him with skills and tools to not reoffend.
Yes.
And he wasn't given the opportunity to participate in either of those.
Not in either one of those, no.
Okay. And so I want to talk to you about the Power Source program. Has it gone by any other name in the last 5 years?
Sometimes people refer to it as violent offender programming.
All right. And TJJD has done away with the violent offender programming.
We've done away with that specific. We still have the capital and serious violent offender program. And now rather than youth doing Power Source, we're doing individualized DBT with the mental health providers.
All right. Let's talk about the capital serious violent offender treatment program. All right. And that is a program offered through TJJD.
Yes.
And that program has certain criteria to get into it.
Yes.
And at the orientation stage of somebody's stay in TJJD, they would be evaluated whether that program is necessary.
Correct.
And at Mr. Blackmore's orientation, it was determined it was not.
Correct.
And at his orientation, it was recommended he do the Power Source program.
Correct.
The Power Source program has some similarities to the Capital and Serious Violent Offenders Treatment Program.
Yes.
It addresses individual needs as well as provides a group setting So there may be reflection amongst peers.
Yes.
And the purpose of that treatment is to encourage empathy, to encourage understanding, and to allow individuals to progress with similarly situated peers.
Yes.
And instead of that, what TJJD offers now is simply individual, was it DBT therapy?
Yes, we do have that.
All right. So the violent offender program is effectively gone and replaced with an individual program.
It still has, so it has two prongs to it. It still has a group program setting that's done with the case manager where they meet for those groups twice a week. And then additionally, on top of that, they're also doing individualized DBT with the mental health professional.
Okay. And so as somebody progresses, they would be engaged in the group setting.
Actually, I mean, they start that the day one that when they come in.
Okay, that's what I wanted to clarify. So power source is gone, but we have many of its elements.
Yes.
And is Samuel engaged in those elements?
Yes, at times he is.
All right. And he was placed in TJJD in what month?
He arrived to orientation on April 10th of 2025.
All right. And when you say April 10th, 2025, that is when he was transferred from our facility in Tarrant County to the TJJD facilities.
Correct.
All right. And at that time, he entered the orientation program.
Yes.
And his needs were assessed.
Yes.
All right. And then he begins rehabilitation. So in those first 4.5 months, he had 75 rule violations.
Correct.
In the next 7 months, he only had 20.
Correct.
And Samuel is scheduled to be placed on stage 4 in the near future. Is that correct?
It would depend on his behavior as well as him being meeting the certain criteria for stage 4.
All right. But that can be done relatively quickly.
Possibly if he were working, yes.
Could be done in about a month or 6 weeks.
I would tend to think maybe a little longer than that. As you get higher in stages, they take longer because there's more criteria that they need to be meeting, and they also have to be meeting all the criteria that's from stage 1, stage 2, and stage 3, as well as meeting the stage 4.
Okay. And so let's talk about how much time we have left. We've used approximately 11 months of his stay. Is that fair?
Yes.
All right. And that's just in TJJD. He had several months before that in the Tarrant County Juvenile Detention Center.
Correct.
And just for his minimum length of stay, we have 14 months left.
Yes. Well, it's October of 2027, so
13 and some change, a little bit more accurate. Oh, I'm
say
bad.
closer to, yeah, I was gonna say, I would say closer to 16 or 17, I think.
Thank you. Lawyers not known for their math skills. All right. So we have about 16 months left before even his minimum length of stay. And we have a downward y-intercept showing that his behavior is improving through the programming.
Yes.
And there is every possibility that in continued programming that he would progress to stage 4 in stage yes.
It is possible.
I didn't hear that. Every what? Mr. Newman?
Every possibility that
Okay, thank you.
in the next 17 months he would achieve stage 4 and stage yes. Now I want to talk to you about the level 2 hearings. All right.
Yes.
You testified a moment ago about a level 2 hearing in June of 25. And I have some documentation in the master file related to a prohibited substance. I have gone through this file and I cannot find what prohibited item or substance we're talking about. Can you direct me to where it's located in the master file? Now I'm going to hopefully provide you a little guidance. I see something on 447 in my notes, bait stamp 447.
Oh, you're looking for the actual level 2? I was looking for the incident.
I'm looking for the 225.
Okay, the
I have a
225.
se-
I'm almost there. The 225 is going to be on page 598.
598, thank you. All right. And so was this substance tested?
I do not know.
All right. Ultimately, he was referred to the psychiatrist per bait stamp 447.
Yes.
All right. And he received some type of medical follow-up.
Yes.
And was Mr. Blackmore on any type of prescription medication at the time?
Yes, he was.
All right. And was that consistent with what was observed?
Explain what you mean.
Well, was the white powder consistent with the prescription medication he identified?
Well, according to the youth, he stated that it was his medication that he had crushed up.
Okay. Do you have any information that would show that this prohibited substance was a non-prescribed narcotic?
No.
And all of this happened 10 months ago. And please check my math. I'm not doing great on it at this point.
Yes, I believe so.
All right. And so if the judge were to return Mr. Blackmore to Texas Juvenile Justice Department, it would be the Texas Juvenile Justice Department's obligation to continue his programming.
Yes.
And could you commit to the court that you would continue the programming and assist in his rehabilitation?
Yes, we would.
If he was successful, you would have the opportunity to parole him.
Correct.
If he was unsuccessful, you could seek another early transfer.
Correct.
There's no bar to you seeking another one later.
Correct.
And if he is somewhere in between those two stages, you could keep him past his minimum length of confinement. Is that fair?
Yes.
All right. And are you committing to the court that if that were to happen, that you would abide by the directive of the legislature and continue your program?
Yes.
And despite the fact that we see a downward Y-intercept of behavioral incidents, it is still the recommendation of the Texas Juvenile Justice Department to transfer Samuel Blackmore to the Texas Department of Criminal Justice?
Yes.
I'll pass the witness, Judge.
Ms. Terrio?
No questions, Your Honor.
Skocelas, all right, so on your kind of the summary on page 3,
Yes.
Underneath the chart, it talks about the egregious behavior protocol, EBP,
Mhm.
right? Is that a new program or new title?
It's newer. We've had it for a while. It's replacing repair. So repair is going away and EBP, I want to say we've had it well over a year, but
That's fine. I just hadn't seen it before. All right. So this is kind of a timing thing that I saw. Do you know when the decision was made by the committee to request early transfer?
initially it was back in July of 2025 when the packet was started. And then in September, Mr. Grove on September 24th did a 60-day set off of that decision.
Who's Mr. Grove?
He's our deputy executive director.
Okay. So I committed him January, I think 25th or January 30th of 25. When did he come into PJD care? When did y'all pick him up?
April 10th of 2025.
And then in July, y'all started the packet for the requesting early transfer?
Yes.
And then Mr. Grove did a 6-day set off. So that would have pushed it off to roughly September or so?
Yes, the end of September.
So I think we received the letter originally requesting early transfer in February. And so what happened in the delay between September to February?
So when there's a 60-day set off, that packet goes basically on hold. And then after that 60 days, we kick it back to the facility for updated recommendations, feedback, and with what the youth is doing. And at that point, the facility updates their feedback, and then it goes back to Mr. Grove, and then he will review it and make a final decision.
I'm just going to ask you this. From the time you took possession of Mr. Blackmore, so from April until July, when you started the red packet to transfer, how would you grade his attitude on A through F?
It was close to an F.
Okay. Then during the Mr. Grove's 60-day set off, that means from July until September or so, how would you grade Mr. Blackmore's attitude at that point?
At that point, it had improved.
I mean, can you give me a grade?
I would probably give him at that point C+, B-.
And then from September, so then during the set off, y'all started the packet again after that set off?
It's not started, it's just kicked back for updated information. So it's basically placed on hold or pause to see if he's going to continue with that behavior. He had shown behavioral improvement, and to make sure that he was going to continue with that improvement was the 60-day set off. Then it goes back to the facility for their feedback again.
So it seems like his attitude improved then, but then TJJD started, I guess, going down the path of recommending early transfer again after September?
After, I would say that it was after December, because the packet was approved in February.
What happened between September and December then?
So September, he had one incident. In October, he had none. In November, he had one. And then starting December 15th, his behavior started going back up. And then come the beginning of February, it started even more.
When you say up, we're not talking up as in positive, we're talking up as in
More
the severity.
incidents.
Okay.
Yes.
And then February is when you decided to go ahead and send the request to the court for the early transfer.
Yes.
So I know in Bates 298, and then multiple times throughout the master file, Mr. Blackmore is repeatedly saying he wants to go to TJJD. He would rather go to, I'm sorry, TDC. He would rather go to TDC, just send him to TDC. And so I understand we're dealing with children. They say things that they may not mean, but how often does this happen where children say, just, I remember the master files I get where these youth will say, I don't care, right? And I know they kind of care, but I don't think I've ever seen a child actually say, I want to go to TDC. Like, how often does that happen in your experience?
It happens. It doesn't happen a lot, but it does happen with some youth.
Like, will they say it over? I'm trying to figure out, and I just don't have the experience with this, like the degree of sincerity when a child says that. I mean, are there youth in your experience that actually do want to go to TDC?
Yes.
I also see multiple references to a diary card, and I haven't seen that before. What is a diary card?
It is part of the DBT programming where the youth has a card where they're going to write down what has been going on and their feelings and everything with it, and kind of identifying. It helps them to identify what's going on, what's happening when they're starting to feel a certain way. Like some days he may, like, I haven't felt like fighting in a week, or I feel like fighting every day. It just depends on what's going on, to make them more aware of what's going on with their feelings and how to better handle them and use those coping skills that they're learning in the programming.
And then, so you had mentioned in your testimony he had lost his diary card. I mean, tell me about, like, what are the rules involving the diary card?
Well, that's part of their treatment program, so that would be an issue if it was lost. And then he would have to make sure that he had requested to get another one to be able to continue monitoring himself. It's really a tool that he uses to monitor himself and what he's doing, and then meets with the MHP to go over it and identify where he's at and what his focus needs to be on. So it would be a problem if he lost it and would need to get a new one.
So I did notice one where one of his level 2s was for headbutting one of the detention staff. And so was there ever a criminal case filed with that in the local county?
There was a review of that through OIG, but not sustained for enough to go up for prosecution.
And there's one other time where I saw, and it involves PREA, and I'm sorry, I'm just not that familiar with PREA since I don't work in a detention facility. So if I recall, there was a time when I guess he was in his pod, and it looks like, I think, a female, I think the name was Maria, was doing checks, and this young man had, I guess he was laying on his bed naked, which was against the rules, and then she called for somebody else, and then he had covered himself after that. Can you tell me the story? Like, my assumption was if a female encounters naked male that they need to call for a male to come by and deal with it. Is that what it is? Or I've never seen that where they called for somebody else.
Looking, because I think that's the one that he received the level 2 hearing for in December. And I think she called to notify the CSA on duty, who's our administrator on duty at that time, to let them know that incident had occurred.
Okay. There's also another incident I saw that I can't figure this out. It said he had urinated under his door. Can you tell me how that happens? Like, don't the individual pods have toilets in them?
I don't believe on the dorms, no, not each individual. It depends on the actual facility and the makeup of that. Do you remember approximately when that happened?
No, there were two times where he urinated inside his dorm, but one of them was it said he urinated under his door, and I can't. Yeah, I didn't write the page number. I mean, at the time it seemed odd, but it kind of came to my mind right now talking to you. That's fine.
I can look through and get that information back.
Okay. I'm sorry. Bates 619. I did write it down. Samuel informed me he urinated under his door while other youth were being disruptive.
Yes.
Like, I'm just wondering how that happens.
It's possible that if there was a big disruption going on, they could not have been able to let him out to go to the restroom. I don't know if he had asked or not, or if he just did it to be involved in the disruption. I mean, it could be any of those.
Now, I think there were some questions earlier about not being in the group program. Like I know you don't do Power Source anymore, but the Violent Offender program, Mr. Newman had touched on this. Was he not enrolled that because he was just too early in the program? I know y'all are, it's kind of whack-a-mole. You're trying to get kids in the program kind of time with their release dates. Is it because Mr. Blackmore just hadn't gone far enough on the wait list yet?
Yes, that was definitely a big part of it. And then his behavior as well, but yes.
Okay. All right. That's all the questions I have from Ms. Coy. Ms. Terrio, did you have follow-up questions?
No, Your Honor.
Mr. Newman?
No, Judge.
Okay, I just want to give you all the chance in case I triggered a curiosity. All right, thank you, Mrs. Coy. Ms. Terrio, your next witness?
We have no further witnesses, Your Honor.
All right. Mr. Newman, your first witness.
Judge, may I have a brief recess to confer with my client?
Or do you want me to put you in a breakout room, or actually just, since y'all are sitting next to each other, what, is there anybody else or do y'all have privilege, or do y'all need?
I would like to go to the back hallway or the holding cell just because we do have a bailiff in the room with us.
Okay, let's take a recess. We'll just wait for you to pop on screen, Mr. Newman.
All right, thank you, Judge.
Okay, friends, we're a little bit in the Wayback Machine here, so I'm going to try to bump past this so we can finish this. Hopefully they're not gone long. All right, there we go. Let's pick it back up.
All right, hello, Dad. Okay, everyone can hear me still?
Yes, Judge.
Yes, Judge.
Okay, so back on the record, Mr. Newman, do you have any witnesses?
At this time, respondent will rest.
Okay. Ms. Terrio.
Yes, Your Honor.
Closing arguments.
Judge, we would just ask that you follow the recommendation / request from the Texas Juvenile Justice Department.
Okay. All right, Mr. Newman, closing argument.
Thank you, Judge. In reviewing the statute, obviously, there are the criteria the court has outlined, but also any other relevant factor. And I think one of the relevant factors this court ought to consider is time. The amount of time he has available left in the Texas Juvenile Justice Department. Ultimately, when we're looking at the experiences and character of the person before and after commitment, let's talk about after commitment. After commitment, we started out in a place where we were getting approximately 20 violations a month. Over the course of the last 7 months, that has dropped to approximately 3 rule violations a month. He only achieved another 20. This is an individual who is demonstrating an ability to be changed by the Texas Juvenile Justice Department. That is what we're seeing in this file. And I think this court should undertake the opportunity that the legislature affords for you to refuse it at this point and give up effectively nothing other than give him the opportunity to get on the program, complete it, get to stage yes, and be a productive member of society. And if that does not happen, this court still has the ability to conduct another early transfer hearing because we wouldn't be bound by any procedural protection for that reason. I would ask the court to deny it at this point, order him back to the Texas Juvenile Justice Department, and let's see what happens when he's given a chance to complete violent offender programming. Thank you.
So this court, having considered all the competent evidence, having considered the experiences and character of the person before and after commitment to the Texas Juvenile Justice Department, having considered the nature of the penal offense that the person was found to have committed and the manner in which the offense was committed, having considered the abilities of the person to contribute to society, having considered the protection of the victim of the offense or any member of the victim's family, having considered the recommendations of the Texas Juvenile Justice Department, County Juvenile Board, local juvenile probation department, and prosecuting attorney, having considered the best interest of the person, and having considered any other factor relevant to the issue to be decided, will order the return of the person to the Texas Juvenile Justice Department without approval for release under supervision. Mr. Blackmore, I am transferring you to the Institutional Division of the Texas Department of Criminal Justice. Because you have been respectful to me, not just this time, but every time we saw each other in court before, I do want to tell you why, because I think you're entitled to know that. I think that's part of my job as a judge, is to explain this. There are a couple things. One is just how serious this offense was. It was an armed robbery of a gas station involving a firearm. This is clearly dangerous behavior. While it was, when you were younger, it wasn't that much younger. It was only a year or two ago. Clearly, there was a need for rehabilitation from your violent behavior, and that's why you were sent to TJJD. Now, while you were there, your attitude has been poor. I mean, I think there's maybe half a dozen times, 10 times that you said, send me to TDC, send me to TDC. What you will learn as a man is that when you say something, people believe you. And I can't help but think, as many times as you said you want to go to TDC, the fact that you're assaultive on staff, the fact that as many times as you've been disruptive, dozens and dozens of times, in such a short period of time too. You were in TDC less than a year, or you were in TDC for 8 months, 10 months before they made the decision that they just can't help you. It is truly remarkable the number of violations that you had. When you look at the numbers that I saw in your master file, that's comparable to somebody who's been in TDC or TJJD for 3 or 4 years, not less than 1 year. But you are just to the point where you're so violent and aggressive and non-compliant that I just don't think you will be rehabilitated in TJJD, and that now you need to be transferred to an incarceration environment, mostly just to protect the community from you. I will also let you know that part of my factor on this one is just your high level of disruption on everything. I find it truly remarkable. That being said, since you are being transferred to TDC, you will fall under some parole the guidelines that they have here. This is a 3G offense. Since it's aggravated robbery and aggravated assault with a deadly weapon, you are not eligible for parole in the adult prison system. You would be eligible under mandatory release guidelines that we have in the state for adults, but not the traditional parole rules that we have. My hope is that you go to TDC and hopefully learn from your mistake and do better. But at this point, I believe, and also I want to let you know, part of this is a policy decision. There are many youth in TJJD who are trying to do better, and keeping you there would just delay them from getting the treatment. There are youth here in our detention facility that are waiting for TJJD, and they can't go as long as you're occupying a bed there. Honestly, you had your chance. You had multiple chances. They gave you the 60-day set off, and you chose not to take advantage of that. I can't devote more state resources to you for somebody who does not want to be helped at the sacrifice of somebody potentially who wants to be helped that can go to TJJD and be rehabilitated and return to our community. Because there was no agreement, you do have a right to appeal. I have a yellow piece of paper copy of the notification of right to appeal. Your attorney will hand that to you before they take you back to the Tarrant County Jail. That does explain that you have the right to appeal. If you cannot afford an attorney for the appeal, I will provide one for you. All right. Is there anything else that we need for the record, Ms. Terrio?
Nothing from the state, Your Honor.
Mr. Newman?
Nothing from respondent.
Okay, that shall be the order of the court. Bailiff, for Mr. Blackmore, if you can just not take him away quite yet, give a chance for Mr. Newman to give him a copy of his certification of right to appeal. All right, that'll conclude this hearing. Thank you, everyone.
Well, friends, I'm not sure how I feel about that one. I need to give it some thought. And Ashley, give it some thought. Maybe this is Thursday's sidebar topic. I certainly think it's something we could discuss. Doesn't have to be, though, but consider it. But yeah, I hope you all enjoyed today. We had some interesting court for sure. We got the history lesson from Judge Middleton, so that was all good. I do have to run because I went further today than I'd intended to. But we will be back tonight for In the Blind with Mike and Dan. Stick here. YouTube will send you over there right after I close out here, so you can set a reminder for tonight. That'll be 7 p.m. Eastern, 4 p.m. Pacific, and I'll be back here tomorrow morning for the live show, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. Go have yourselves a great day, and hopefully I'll see you this evening over at In the Blind. Take care. God bless.